Adjutant.
Here.
Oh, I started without my sheet here. Infantine, yes.
Here.
Seaworth.
Here.
Avalani.
Present.
Callum. Callum.
Here.
Mackey, here. Love.
Here.
Warden. Turcott.
Yep.
Prout. Prout? No Prout. Okay. Boyd.
Here.
Huff.
Here.
Sullivan.
Yep.
Susie.
Here.
Baruti is substitute Chris Schultz.
Where's Representative Schultz?
Not here yet, okay. Okay. Cahill.
Here.
Di Silvestro.
Here.
Schmidt.
Here.
Toomey.
Here.
Bouchard.
Here.
Manival.
Here.
Okay.
All right, thank you, everyone. We have 7 bills in front of us today, and then the plan is executive session this afternoon after we take a little break after our last hearing on House Bill 1569. And I have a couple of announcements, but I can't remember them right now. I'll remember them. I'm going to open the hearing on House Bill 1363 and recognize Representative Roy. All of you this morning will have received an email from me. If you, Representative Roy earlier this morning sent me an amendment, which we don't have out of OLS, but I sent to you all via email. So if you have your email access, you can look at it. If not, we'll try to get copies of that. Representative Roy, thank you. Welcome.
Thank you, Mr. Chairman, members of the committee. I'm here today. I'm Representative Terry Roy, Rockingham 32, to introduce for your consideration 1363. I believe this is my first time in front of this committee in two terms, so I will introduce the bill the way I introduce all my bills. I don't ask you to OTP my bill. I ask you to consider my bill. It's now your bill. You're the subject matter experts. I submit it for your consideration. This bill originated from a constituent and then several constituents. The reason for the bill is several of these constituents had signed non-compete agreements when they were hired. The non-compete agreement did not have any contingencies about separation other than if the employee left on their own. However, when an employee is terminated, it turns out they're still locked into this non-compete agreement. So what happened was, unfortunately, all things apparently go back to COVID these days. They were given the choice, take the vax or get terminated. They chose not to, which is their right and the employer's right. However, the employee is still holding them to their non-compete agreement. So what that does is, in effect, it sideslides them for an entire year with no ability to make money, income, or continue. They have a gap in their resume. So I originally wrote the bill, honestly, not knowing what the heck I was doing. I just tried to figure out a way to do it, and I overcomplicated it. Last night, I discussed it, ran it by my wife, as I often do, and she's from Atlanta. And after I got done reading it to her, she said, "Oh, sweetie, bless your heart." I knew I was in trouble. That's never a good thing from a Southern woman to hear. She's a director of human resources at a billion-dollar company. She knows what she's talking about. She said, "Terry, you overthought that. Make it simple, make it sweet." So that's what I did. This bill, as amended, if you will adopt the amendment simply says, if you are terminated, the non-compete becomes void unless the employer wants to pay for your time. In other words, when you sign a non-compete agreement, you agree, I'm not going to go to one of your competitors and take my mind and my intellectual property that I've developed, or my skills or knowledge or my sales contacts with me in your company, which is legitimate. I don't think we should be getting involved in private contracts unless it affects the public in such a way like this, where it actually would freeze a citizen from making any more money in their field. So for example, sales, and this is one of my constituents, she's a salesperson, does good business. Her employer asked her, vax, she said, "No, thank you." They said, "Okay, well, Thanks for working for us. Keep in mind, you can't work for a competitor. Well, that's all she knows. That's her field. That's her expertise. So for an employer to be able to free someone out of the employment market for an entire year is wrong. No matter how you look at it, it's wrong. So, in the interest of the employer, there's a way for them to get out of that. If they want to buy that employee's loyalty for that entire year, then they should continue to pay it. So the amendment, as it's written, says if you're terminated and they wish to hold you to the non-compete agreement, they have to continue your pay and benefits for whatever term the non-compete agreement was. So if you have a one-year non-compete agreement, they can terminate you, but for that year, they have to buy you and buy you out and pay you as if you were still working there. That's your health insurance and your pay and compensation. Or I also put in there that the parties can renegotiate the agreement so that the company could say, okay, we'll let you out of it, we'll give you a lump sum. There's still the ability for the private renegotiation of the deal. But at the end of the day, if the employer is not interested in that, they have to pay it. And if the employer refuses to do that, and the employee is forced to litigate to get their money or their freedom, I've provided some teeth whereby if they prevail in court, they're entitled to up to treble damages and their attorney fees. According to my better half, an expert, most companies will avoid that and they'll just buy the employee out. But at the end of the day, no one should be frozen by an agreement that they entered into that had no contemplation of something like this happening to them. So, having said that, I'm open to questions. Thank you.
Thank you for your testimony. Are there any questions for the presenter? Representative Seaworth.
Thank you, Mr. Chairman, and thank you for presenting this bill. I was wondering, we had another bill trying to deal with a very similar subject in a slightly different way. It was HB 1089, sponsored by Representative Kofod. Have you seen that bill?
No, I have not, no. But
Won't
if there's
quiz you
another
on
bill
it.
out there, I mean, whatever car drives, I'll get into it.
All right, thank you.
Any other questions? I have a question, Representative Roy. Since I'm involved with non-competes in my business, there's a couple Supreme Court rulings in New Hampshire over the last 5 years that pretty much made most of the most egregious parts of non-competes illegal. You cannot, as I think the judge stated in his ruling, preclude someone from being able to work. Yes, you can say they can't go after the same clients. Yes, you can say you can't use their intellectual property. Yes, you can say you can't take their trade secrets, but you can't stop someone from working. You can't say you can't work within X amount of miles or things like that. So I'm interested in knowing a little more about individuals who were let go. And is it your intention that if the employer doesn't buy someone out, that it's okay to go after their client base, utilize their intellectual property, utilize prior sales leads or things like that? Because non-competes have a lot of stuff in them.
Absolutely.
Not that you just can't work.
Absolutely, they do. And the intent of the bill is solely the employment piece. Intellectual property remains intellectual property, and I believe there's even U.S. Supreme Court cases that deal with that. So no, this would not be, and if it looks that way, please, let's amend it. I do not want this to make it so that employees can steal intellectual property or anything, client bases that they developed through their employer or part of their employment. It's simply the work part. Now, as you said, there are some Supreme Court cases from New Hampshire, but they didn't deal with termination or involuntary separation, to the best of my knowledge. They dealt with people leaving on their own, trying to get work somewhere else. So my sole goal in this is so that people who are terminated for cause, and regardless of the reason of the cause, it doesn't have to be COVID, should not be frozen out of work for a year. And so far, the court hasn't addressed that issue. So if we need to fine-tune this, I'm happy to do that. I think that's a good idea to specify IP and things of that nature. It's about the employment itself, that they can work. And even if it is for a competitor, because
that is their area of expertise. If someone works, pardon the frogs in my throat, if someone works in sales with a particular product area, to tell them, well, you can still work in sales, but you got to go learn this whole new product area and develop your, I mean, it's not fair for someone who's spent their career building that wealth of knowledge, as long as they're not taking the knowledge that was the property of their previous employer.
All right, one other question. Would these cases of individuals who were terminated for refusal to be vaccinated, were they involved with the healthcare industry?
No, they were sales, nothing to do with healthcare. One of them was, I believe, actually beauty products. So it wasn't healthcare.
Okay. Are there any other questions for the presenter? Seeing none, thank you very much.
I appreciate your time. Thank you.
Yep. I'd like to next call Peter Mcnamara from the Department of Labor. Dave Juvet, you're next.
Good morning. Thank you, Mr. Chairman, and thank you to the committee. My name is Peter Mckenna, and I'm an attorney with the New Hampshire Department of Labor. Happy to answer any questions, but I wanted to note a few things about HB 1363 that we've noticed here at the department. There's two things mainly that I did want to note. The first is that the bill does define what a critical shortage is, but the bill does not appear to define what it is when a job or skill set is in high demand. So the bill does not appear to give the department any guidance when we would make a finding or how we would make a finding as to when that is in high demand. It's very straightforward as to how we would find something is in critical shortage, but we don't seem to know how we would make that finding, and it seems a straightforward fix would be to simply say, if there is a critical shortage, then it is in high demand. It would stop any discretion on our part. It would be a simple and straightforward mechanism for us to enact in that way. The second thing that we noticed is also along the lines of discretion. The statute says that the commissioner may suspend non-competes in such a situation. And again, it's not clear to us when or how that discretion is expected to be utilized, what the standard would be for the commissioner in terms of deciding when to utilize that discretion and when to suspend those non-competes. And again, it's up to the committee and it's up to the legislature in determining how it wants to give that discretion. But it may make sense to, again, say if there is a critical shortage and if there is a high demand for that skill set, to simply suspend those non-competes for a period of time. If there is the desire to give the Department of Labor some discretion, then imposing a standard on the commissioner and how that discretion is utilized might make some sense, because right now the way the bill is written, it just sort of says, or it reads that the commissioner may suspend, and it gives the commissioner discretion in defining how it may suspend and in how it finds whether the job or skill set is in high demand. So those are the points of clarification, if this bill were to go forward, that the department would like to be clarified or might be helpful to clarify going forward. Other than that, we take no position on the bill ultimately, and I'm happy to take any questions if there are any for the department.
Mr. McNamara, I'm not sure if you heard at the beginning of the hearing, Representative Roy has had a complete rewrite of his bill, an amendment. I know you were referring to what's in front of you, and I respect that. We'll try to get you that copy as soon as possible so you can opine maybe via email once you get that and see the perspective changes. That being said, any questions for Mr. McNamara? Easy one for you. Thank you very much.
Thank you.
Mr. Juvet has not put a pink card in, but I'm making him come up anyway. Okay. 5 years ago, when Representative Keith Murphy in this committee submitted something that you must have if you have a non-compete, you must present it to the employer before you hire them. You brought me in front of your HR committee, and I got raked over the coals for the bill, which seems pretty minor now. So I knew you probably had something to say on this.
All right. How's that? For the record, my name is Dave Juve. I'm a Senior Vice President with the Business and Industry Association. And for those of you that I know on a more personal level, I am pleased to say I'm no longer interim president. We have a new president at the BIA, so that's a responsibility I'm happy to be free from. Mr. Chair, I'm glad you clarified what is happening right now, because I was sitting in the back looking at 363 going, this seems, it seems like we're talking about a different bill. So I will quickly adjust, and I remember that situation 5 years ago. I do not remember you being raked over the coals. My memory is we treated you very respectfully.
No, you did. I'm having some fun with you, David. Yes, you did.
I haven't seen the amendment, but I was able to hear the prime sponsor's explanation, and just a couple of concerns I would like to share with the committee. The first is there are many companies in New Hampshire, and there is a potential for many other companies to be added to this list that are under a federal vaccine mandate. Right now, any employer that is receiving Medicaid or I think Medicare money is required to have their employees vaccinated. And there are exemptions that are provided for religious beliefs or medical reasons. But nonetheless, the employer is required to implement that mandate. So there's really no flexibility on their part in terms of an employee who chooses that they want to leave. Secondly, in hearing the description of the amendment, it occurs to me that it would require this essentially one-year severance for termination, but there are many reasons that employees may be terminated because of their own behavior. They could be having repeated work-related infractions. They could be threatening other employees. They could be stealing from the company. The list is endless, so it seems inappropriate to require a company to pay them essentially for a year of work when they've been terminated for cause. And then the third thing I would like to remind you, and the chair already did a great job of this whole issue of non-competes was discussed thoroughly in this committee and in the House and Senate, and I think it was resolved in a way that was both fair to employers and employees. So this, at the very least, would upset a system that it seems to be working for everybody. So, Mr. Chair, I'd be happy to answer any questions.
Thank you, Representative Love.
Thank you for taking my question. Thank you, Mr. Chair. Would you believe that people have been fired over Facebook posts with political views?
I guess I'm willing to believe it. I'm not aware of that in my own experience, but would you believe that employers now are so strapped for employees that they are almost doing anything other than terminating people because they're having a hard enough time finding people to fill vacant positions without adding to that problem?
Follow up, Mr. Chair?
I believe both of you. Yes, follow up.
Would you believe that's going to end? You know, we're going to get past that. I do know people that have been fired over their Facebook posts. You know, fired for cause, terminated for cause, okay. You know, but when an employer is allowed to do that, you know, and then enforce a non-compete agreement, I have a real problem with that.
I respect our difference of opinion.
Representative Cahill, and then followed by Seaworth, maybe.
Thank you, Mr. Chair, and thank you, Mr. Juve.
Certainly.
Correct me if I'm wrong, but is not New Hampshire an at-will employer state?
Technically, yes, although, as you and I both know, there are occasions or exceptions to that. But in general, yes, it is an at-will state.
Thank you.
Representative Seaworth.
Thank you, Mr. Chairman, and thank you for your testimony, and I'd like to draw on your expertise if you can help us.
Now you're making me nervous.
Yeah. So, during the presentation, the chairman brought up, well, I'm referring to your comment about how the law seems to have settled into a good balance right now. The chairman brought up an issue that I have some concern about, that there are Supreme Court cases that dictate, that limit non-compete agreements that are not reflected in the law. So I'm wondering if there's a gap between what the courts would do if it went to court and what the Department of Labor is allowed to do based on the written law. Any
Yeah,
comments you have on that?
Certainly. Thanks for the question. I should make sure everyone clearly understands I am not a lawyer, and I'm especially not an employment law lawyer, although we have many of those within our membership whose expertise we could draw upon. If that is the case, and it seems reasonable that it might be, I might suggest rather than going through with this, you might want to consider forming, whether you do it statutorily or not, forming a group to look at the state of current non-compete statutes and the impact of state or federal Supreme Court decisions, and see if there is some type of remedy that is needed. And we would be happy to participate in that.
Representative Mandeville.
Thank you, Mr. Chairman. Thank you for your testimony. Would you or your organization say that the right of an employer to negotiate with an employee for a non-compete clause is an important and valuable right that that company has?
Yes, I would say for some I think we can all agree that most companies in the state don't have non-competes, but some do, and for them it is very critical.
Thank you.
Any additional questions? Seeing none, thank you.
Thank you, Mr. Chair.
Representative Love, would you turn off your microphone, please? Sorry. Thank you. Are there any other individuals who would like to speak on behalf of House Bill 1363? Seeing none, thank you very much. I'll close the hearing. I'm going to turn the microphone over to Vice Chairman Seaworth. I have to present a bill in another committee. We'll be, in 5 minutes, we'll be having the 11:43. Representative Sullivan.
Mr. Chairman, did you intend to include this bill in the bills to be exec today? It's on the list.
No, I did not.
Thank you.
But I'm going to make you do it just because you asked me. I said no favors today. No, I have to try to do
All right, if I could have everyone's attention, we've still got a few seconds before the hearing starts. Before we open the next public hearing, some questions came up about what's on the schedule for executive session later this afternoon. The chairman did send out an email on February 4th. Some of us may have read and forgotten. Some of us may have missed that. So I wanted to read down the bill numbers that were in that email, just so everybody has that and can think ahead. He did remind us that he may add others. He may take them off as circumstances dictate, but here is the list that he sent. HB 1053, HB 1076, and I won't say HB every time, 1094, 1124, 1251, 1358, 1363, 1415, 1472. All right, and with that, I made us a bit late, so that the chairman's mother doesn't give me a call, I will get us started here. And we have Representative Mark Allegro, the prime sponsor of the bill.
Good morning, Mr. Chairman, and good morning, committee members. My name is Mark Allegro. As was just stated, I'm the representative from Grafton's 7th District, comprised of Campton, the town of Campton. And I'm here, I sit on the ED&A committee, and I hear very frequently when people come up to testify, this is a simple bill. And I'm sorry, but I'm going to lay that one on you here now. This truly is a simple bill, and I'm just going to talk in two little clusters here. I'm not here to debate or really even to make a point of the efficacy or the safety of the vaccines, or even whether they should be called vaccines. But it's critical that the people on this committee and the public understand some facts about it in order for me to turn off my phone, which I didn't silence. There we go. Excuse me. Many of you are familiar with the CDC and FDA VAERS site. It is under the auspices of the Department of Health and Human Services, the U.S. Department of Health and Human Services. The acronym VAERS stands for Vaccine Adverse Effects Reporting System. So the point here is that people are losing their jobs for requesting exemptions to vaccination. And I want to explain to you the efficacy, the dangers, and the reason why these people may be hesitant to be vaccinated. Again, this is from the Vaccine Adverse Effects Reporting System. This is the National Institutes of Health, CDC, and FDA. When we get through with this, some of you may choose to not believe it, but here are the scientific facts. From the years 1990 to 2021, there have been 137 deaths related to vaccine administration for all current vaccines put together. Okay, that's an average of a little over 4 per year. This is in the state of New Hampshire. In 2021, we started administering the COVID vaccines. For that 1 year alone, there were 64 deaths in the state of New Hampshire. That's 16 times more deaths on an annual basis. It's more deaths than all other vaccines combined, or I should say it's on the order of the number of deaths for all vaccines combined for 31 years, just that one vaccine. Please feel free to interrupt me if you have any questions on that statistic. That doesn't count hospitalizations, permanent disabilities, other injuries like miscarriages, or even what some physicians are telling patients are normal reactions. For instance, lymph nodes swollen up to the size of golf balls, okay? I have a little bit of background in immunology, and I'm here to tell you that when your lymph nodes swell up to the size of golf balls, or you land in the hospital for some other reason, that's not a normal response to a vaccination. So, you know, the counter argument to all of this is that, well, compared to the number of deaths that there might have been if these people weren't vaccinated, it's a small number, and that's true. And here's where I'm going to wrap up the discussion of this data. That's akin to asking somebody to play Russian roulette. You put in a bullet, you spin the chamber, you hold the gun to your head, and you pull the trigger. The chances are not big that you're going to blow your brains out, okay? But is there anybody in here who wants to play Russian roulette? Is there anybody here in this building who would like to be forced to play Russian roulette? I can answer that question. We can each answer it for ourselves. So the rest of what I have today is relatively brief. Last year at about this time, maybe 8-9 months ago, we had a big debate about vaccines and employment. And it was a common point made by our friends on both sides of the aisle that we can't be telling businesses what to do. They have to take responsibility. They have to make their own decisions. There's a great deal of merit in that argument. But I also would put to you that in addition to the power to make their own decisions, the responsibility of making their own decisions includes not throwing another tax burden on the people of New Hampshire. So you can't take a vaccine because you've had a heart attack, you don't feel safe doing it, or you have a religious exemption request, or you just don't want to, all right? What I would like this bill to say to businesses is, it's your decision. If you want to release that person, it's your decision. But it's also your responsibility. So now 100, I've been in touch with our Department of Employment Security, made sure that some of these things that I'm saying, because I'm no employment expert, 100% of unemployment insurance is paid by the employer. The trouble is that these people who were released because they didn't want to or couldn't take a vaccine or had natural immunity, is that they don't receive unemployment insurance. This bill proposes that employers who choose to release employees for that reason make available a severance package for these employees. Well, why? Never mind the misery and truly inhumanity of dumping somebody without a job in this market today where many businesses choose not to hire you if you're not vaccinated. But in addition to that, taxpayers often pick up the tab on other benefits programs like food support, supplemental nutrition support, and so on and so forth. In addition, there's a cost to all taxpayers at the federal level, which includes we, New Hampshire citizens. For instance, the administration of unemployment, of the unemployment program paid by, excuse me if I don't know how to pronounce the acronym, I'll spell it out, FUTA, it's the Federal Unemployment Tax, pays for the administration of unemployment benefits in the individual states. If there's more unemployment, there's a higher cost in administering it. Folks, it's coming out of your pocket and my pocket and the pockets of other people across the country, just as our New Hampshire, just as we're paying a federal tax here in New Hampshire for people in California to administer these programs. I pointed out that taxpayers often pick up the tab on food stamps and other benefits programs. In addition, the cost to all taxpayers, federal taxpayers, which includes we New Hampshire taxpayers, can be increased due to the, well, is increased. For instance, the federal government pays unemployment under specific programs, such as the Trade Act. I don't have to repeat that the federal government doesn't have money. The money comes out of our pockets, the taxpayers. And the feds can pay up to 50% of extended benefits during high unemployment. So here's the deal in a nutshell. Businesses should, there's a great deal of merit in the argument that businesses should have the ability to release employees who don't want to or cannot, for whatever reason, are not vaccinated. But at the same time, to cut them loose in the sea of unemployment with no support and foist some of that cost on we the taxpayers is wrong. This is a simple solution. It says businesses, go ahead and fire them, but you're going to have to take the responsibility off of the taxpayers' shoulders, and you're going to have to provide a severance package, it can be viewed as. A severance package for 6 months, up to 2/3 of the employee's compensation package. And we've all taken responsibility for our own actions. The employee, the employer, the taxpayer, and most importantly, the New Hampshire House of Representatives. With that, I'll be happy to answer any questions, and let's abandon House etiquette, be direct and hard with any of your questions. My career as a researcher and educator for 40 years, that's what I've done, is answer questions. I love answering questions. Hit me, please.
I would ask the committee to refrain from abandoning etiquette, and
Bend it a little bit. Just,
but we'll ask if anybody has questions. I'll start with Representative Sullivan.
Thank you, Mr. Chairman. Thank you for taking my question. Thank you for your testimony. In many ways, very compelling. One of the things that Mr. Juve said in the last hearing is that one category of employees that is hit with the vaccine mandate are medical employees, and I'm thinking about our other job back in the county, taking care of our county nursing homes. Those folks have to be vaccinated or they have to be terminated. You expressed a lot of legitimate concern about placing a burden on taxpayers. Our county nursing homes are paid for by tax dollars, and if we have employees who are getting a 6-month pay compensation, that comes from tax dollars in the county. How do you respond to that?
yeah, you're right, and that's a good point, and thank you. And if I were going to request or suggest an amendment for that, I would make provision for government entities, well, for healthcare, government owned, government-run healthcare entities. If it's a private healthcare facility, then I think it should fall under this same, the provisions of this bill. But if it's a government entity, then it should, you know, the provision should reflect current law, which says that healthcare, the government-run healthcare industry can release patients. However, if I were going to ask for or you know, be highly pleased with such an amendment, I would point out how flush our general fund is right now and our rainy day fund, and how highly available federal funds are. And I would suggest that some provision be made for these employees as well from county and other government-run healthcare facilities. But thank you, that's a good question.
Representative Babalani.
Thank you, Mr. Chairman. Thank you for taking the question, Representative. Part C, lines 10 through 13. So the employee gets 6 months severance, walks down the street, gets hired by a non-mandated employer the following week. So the previous employer gets dinged for 6 months. The employee makes out on the deal and has a new job the following week. How do you rectify that?
I do not have the bill in front of me, but that is not the intent of the bill. If an employee or a former employee finds employment, unless that's gosh, OLS, please help me. The intent of the bill, as I expressed it to OLS, was that if an employee finds employment, the problem is solved. I'm not looking to punish businesses. I'm not looking to punish employees or have anybody benefit unnecessarily. Somebody comes out, finds a job 2 weeks later, well, the severance package is no longer in order. Did I answer the question? Is that? Thank you.
Follow-up.
Thank you. First part is right. So who would monitor that the employee is no longer working? Would it be the former employer? Would it be Employment Services? Would it be DOL? Would it be the actual employee?
Well, if I were paying the fee, I would be monitoring it. Actually, another aspect of this bill, which I did not discuss, is the idea that the employees need to file with the state a plan and a policy, and that policy could mesh with monitoring employees. Built into the severance program that the company puts out as their policy could be a biweekly or a monthly report from the employee confirming that they have not found additional employment. Very much like our unemployment system now. I mean, and the state as well could monitor this just as our current unemployment system is handled. Thank you for the question.
Representative Warden.
Thank you, thank you. My question is regarding the 2/3 of the salary and benefits received, but a lot of people that are in sales receive bonuses and commissions. And the way this is written, it's my understanding that those would not be included because it only refers to salary. Is that your intention?
Well, that's correct. You can't account for bonuses and commissions. This plan, as it's written, is somewhat more generous than our regular unemployment system, which provides a maximum of, I think, $430 or so for unemployed individuals for up to 6 months. This provides something closer to reality for that employee. So, yes, it's entirely possible that they're not making their commissions, but it's something to put food on the table.
Representative Turcotte.
Thank you, Mr. Chairman. Thank you, Representative, for taking the question, actually two-part. Would you say that the policy statements that you're looking for here, a policy, in your opinion, is that something that a private business would develop on its own?
Yes, because this isn't state law that they're developing policy on. This is company law. And the only difference is that we want this policy to be available to the employee and to the state, as well as to potential employees of that company. So this isn't, the situation is not that the state is going to approve policy, but it's going to be on file and available as a public record. Did I address the central issue?
Follow-up.
Yes. The second part of that question, though, goes to, since this would apply to private employers, and as we on this committee have said, and you in your opening remarks have said, we tend to not get in between the private business and their employees. On line 7 where it talks, it says the policy at a minimum shall, and then it goes on to, in what term I would use, would dictate 3 specific items that the employer must include. Would it, my interpretation of that is that we're dictating policy to a private business. Would that be your intention?
Well, we do that all the time. Although we all like to run around and say that we don't interfere with private businesses, we do. We require policies and plans regarding occupational safety and health to be filed of all businesses. So I'm looking at the wording here, the policy at a minimum, so it's up to the corporation or the company, the business. Permit an employee to opt out of the medical mandate. Well, that's the whole central issue here. They're already allowed to do that. Permit an employer to terminate an employee. That's what we're claiming is their right. But then to require that employer to put on record their policies in making such decisions. In other words, if one person comes with a health matter, it has to be clear why they can say no to that employee and yes to this employee. So, all jesting aside, telling businesses what to do is what we do here in the legislature. Okay? It's what we do 365 days a year. So I did point out that this was part of the debate 10 months ago, but I'm not saying that I'm on board with it. We tell businesses what to do all the time, and we just came off of a 2-year period of telling businesses what to do at an unprecedented level. So asking them to file, you know, this would be how I would say it, asking them to file a policy that could be made available to employees, potential employees, and citizens of the state. It's a minor thing, I think. Please do.
One more follow-up.
Just to be clear, I'm not unsympathetic to where you're trying to go with this. I'm just saying the way that it's written actually does go and dictate specific things that would apply to a private employer. The other comment that I will make, so you're aware of, we in this committee have seen multiple bills that are all kind of overlapping like this, and I would say this might fall partially into that, just for your information.
Was that a question?
Would you believe?
That's great. I got to remember that. So yeah, may I just comment to that, yes, or answer that question? Yeah, I just want to set the record straight that I don't think it's a powerful argument that we shouldn't be telling businesses what to do. Or rather, it is a powerful argument, except that we here in state government really don't adhere to it at all. So this is a, I know some of us more than others, this is a case where, you know, I think that the rights of the individual have to be placed somewhere up there with the rights of the businesses. That has been the counter argument to what we're discussing.
Further questions? And I'll come back to Representative Avalani after giving Representative Love a chance.
Thank you, Mr. Chair. Thanks for taking my question. You know, there's a lot of questions, you know, have come up, but you won't get an argument out of me as far as the safety of this vaccine. I've got family members that have been injured by it, friends that have been injured by it, and, you know, there's no recourse. One thing I would like to ask is, would you be okay with an amendment, and I think it'd cover a lot of these bills that, you know, we're getting hit in every direction with them, to relieve the company of any liability from an employee coming in saying, I caught COVID here, and I'm suing you. And on the other hand, okay, give the liability to the company if somebody is injured by a mandated vaccine. You know, whether it's 5, 10 years down the road, if it can be proven that any vaccine I'm talking, you know, if you mandate it, if you force your employee to get it, you're liable. Would you be okay with an amendment?
I would be, and amongst the bills that Representative Turcotte was speaking of, I don't know if it has persisted or if it was withdrawn, but I know there was one House bill that addressed the issue of injury due to mandated vaccine. If this bill now belongs to the committee, and if this committee wanted to put that in, I'd be delighted. Let me address the other side of that coin. An employee, you know, this is my bailiwick, and I'm here to tell you, in spite of all the contact tracing and all of this other business, I'm going to say this strongly. There is absolutely and utterly no way to tell where and when someone caught the bug. This is just scientific fact. all the contact tracing in the world. There are times when you could tell when it's highly unlikely that a person caught the bug at a given event or place because there's a natural incubation period, but even those have very fuzzy borders. So normally, 1 to 4 days later, if you've been exposed, you might start coming down with symptoms, but that can stretch out to days or weeks. So it is completely and utterly impossible to tell where and when someone caught the bug. On the other hand, when someone goes in for a vaccine and 3 days later collapses and is carted off to the hospital, we see it in the news occasionally. This because it's a celebrity. This celebrity died. Eric Clapton couldn't play his guitar for months within days after taking the vaccine. The burden of proof will still need to remain with the person filing the complaint. But I repeat, the bill is now the committee's. I would support and be very pleased to see a provision like that put in as an amendment. Thank you.
Thank you.
Representative Valvani.
Thank you, Mr. Chairman. Thank you, Representative, again. Line 5, an employer, are you talking every employer that has 1 employee or 1,000 employees, just so we're clear?
Every employer.
So, and follow up, Mr. Chairman? So if a mom and pop with a single employee requires a vaccination because there might be compromised, and they want their employee to be, not as much of a risk. So the single mom and pop would be on the hook for 6 months of severance pay?
Yeah, this is an opportunity for citizens and neighbors to work out problems amongst themselves. And they can tell somebody, look, we're not going to mandate you to wear a mask, or we're not going to mandate you to keep 6 feet away, or we're going to change your duties a little bit. I hope this is okay with you. Let them come to an agreement between employee and employer. But yes, this is an employer. Yes, their responsibility is the same to their employee, just as if they had 30 employees.
Thank you.
Thank you.
One more follow-up?
Thank you. Representative Warden brought up a great point about non-salaried employees or bonus or commissions. Would you have a look, under Section C, would you have a look-back period added for 3 months, 4 months?
That's a good idea. And actually, I missed that important point in there. When the question was raised with me, immediately to my mind came the idea of employees who are on a salary but also receive commissions or bonuses or tips. And I didn't understand or hear the point that some people are on commission and such 100%. Yeah, thank you. That would be a good solution to that matter. It would take care of it very nicely, I think.
Representative Mandeville.
Thank you, Mr. Chairman. Thank you for providing testimony. I may be the only one who struggles with this, so forgive me if that's the case, but the meaning and extent of the phrase medical mandates is what I focus on. And for example, I wonder if a business has a rule that, and it's mandated on employees that they not come into work if they have a cold, flu, or persistent cough, and an employee thinks, well, here's a chance to get a nice severance agreement by deciding to come in. That's just one example. I don't know if you could define for us what the intended breadth of
Sure.
what a medical mandate is on the statute.
I think the answer to that is inherent in the bill. If, let's take the example you cite, which is a good one, because people are willing to come in and work themselves to death with the flu or a cold or whatever, and they can infect other employees or the owners. But that's not a terminating medical mandate. An employer has the right to tell an employee, look, you're sick as a dog. I don't want you making everybody else sick. Go home. Right? He's not saying you're fired. He's saying go home, come back when you feel better. and I'm putting it rather casually, but this is in fact the point. Now, what could lead to a termination if that employee says, no, by gum, I'm coming in and working? Well, that employee has resigned, in effect. It's not a case where but to answer your question more fully and take in all contingencies, if an employee comes in with a head cold and the employer says you're fired, then the answer to your question is yes. Thank you for the question.
Are there any other questions for the sponsor? Seeing none, thank you very much for presenting your bill.
Thank you very much for considering and for taking my testimony.
Next up, I would like to call Peter Mckenna to represent the Department of Labor, who does not take a position on the bill.
Thank you to the committee. My name is Peter Mckenna, and I'm an attorney with the New Hampshire Department of Labor. I'm happy to take any questions that you have, but there are a couple of things that we did want to note about this bill. This bill would be amending a section of RSA 275, which would be under the Department of Labor's statute, and it would fall under the department to enforce this. So there are a couple of questions or points that we would want to clarify about the bill if it were to go forward and be passed. It was mentioned, and it is something that we would want clarified as well, which is the definition of a medical mandate under the bill, because there are some clarifications as to what that actually would mean to not clarify, to not comply with a medical mandate. The one that we had a question about actually would be a drug test, to not comply with a drug test. There is a question as to whether requiring people to comply with a drug test is a medical mandate of an employer. And if an employee said, I'm not taking a drug test, and they were terminated for refusing to comply with a drug test, have they refused to comply with a medical mandate, and would they then be entitled to 6-month severance under the bill as currently written? It's unclear to us if they would be, and if we were called to enforce the bill, it's unclear how that would come down with the bill currently written. And so some clarification going forward if the bill were to be passed on that point would be helpful. The second point that we think clarification would be helpful is in what the monthly severance pay would actually be, because there's two ways that we could currently read the monthly severance pay. Let's say that you have an employee who made $100,000 over the life of their employment, but they averaged $1,000 a month for their salary. You could read 2/3 of the value of the employee's total compensation two ways. You could say that one, if they were to be, their monthly severance would be $66,000 per month for 6 months, because that's 2/3 of the value of their total compensation is $66,000. So they would get $66,000 per month for 6 months, or you could read that as $666 is their 2/3 of their monthly average wage. So that's what they would get for 6 months. It's unclear from the way the bill is written, so we would like some clarification on that point going forward. I think those were the only 2 points that we had about enforcement and clarification. If you have any questions, I'd be happy to answer them, but those are the only 2 points we wanted to raise.
All right, thank you for your testimony. Are there any questions for the department? I don't see any. Thank you very much.
Thank you.
Next up, I'm going to ask Paula Minahan to come up. She is representing the New Hampshire Hospital Association and is opposed to the bill. She has some written testimony as well.
Good morning, Mr. Chairman, members of the committee. For the record, my name is Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association, representing all our hospitals in New Hampshire. We are opposed to House Bill 1143. Let's see, the position, it is our position that employers have the right to determine what is best for their employees and their clients, patients, and/or patrons. While this bill does not define, as stated, what a medical mandate is, it could be interpreted to mean, and it sounds like that was the intent of the sponsor, to mean requiring vaccinations as a condition of employment. Requiring vaccinations of healthcare workers from communicable diseases is not new for hospitals, and I think I've already testified to that in front of your committee on another bill. Hospitals have required vaccination against several communicable and deadly diseases such as mumps, measles, rubella, chickenpox, diphtheria, tetanus, pertussis, and influenza as a condition of employment, with the same type of medical and religious exemptions allowed for COVID-19. We believe it is absolutely the right thing to do for the health and safety of our patients, our staff, and the citizens of New Hampshire. And the vast majority of hospital staff have been vaccinated against COVID or have received exemptions. And we've heard from many healthcare workers who support the vaccine requirement. So I think that's an important point, that they feel safe and going to work because people are vaccinated, or that is a requirement. Hospitals are private organizations and have extensive written policies regarding employment requirements, including vaccination requirements. This bill would require all private employers to submit their policies to the state. We believe it's onerous, and we question the authority and appropriateness of such a mandate on private employers, and why just policies regarding medical mandates, as the bill states. Hospitals are regulated, as most private employers, by the Federal Occupational Health and Safety Administration, not necessarily by the Department of Labor, so that's somewhat of a conflict. We are also, it's important to note that very, very few individuals have either chosen to leave employment with a hospital due to this requirement or have been relieved of their position. However, this bill would cause, we believe, a perverse incentive to encourage individuals to choose to not to comply with the requirement to be vaccinated, since this would they'd end up receiving 6 months of severance. The bill before you does not is not specific to COVID vaccines, which causes additional concerns and confusion for employers due to the open-ended nature of the bill language. We also question why this bill does not have a fiscal note, and after hearing the testimony of the sponsor, it sounds like it would be actually pretty extensive requirements for the state, and we believe that there is a measurable financial impact to the state of New Hampshire, including to include increased litigation and associated court costs, not to mention all the other reporting, et cetera, that is contemplated. We are opposed to this bill, and we urge the committee to find it inexpedient to legislate. Happy to answer any questions.
Thank you for your testimony. Are there questions? Seeing none, thank you again.
Thank you.
Next, I'd like to ask David Juvet, representing BIA. He is speaking in opposition to the bill.
Thank you, Mr. Chair. And for the record, my name is Dave Juvet. I'm a Senior Vice President for Public Policy with the Business and Industry Association, which serves as the statewide Chamber of Commerce. We have approximately 400 plus employer members with over 80,000 employees throughout the state. We are in opposition to this bill. A number of our reasons for opposition have already been articulated, so I won't dwell on those, but I will focus on the lack of a definition for medical mandate, because that's very broad, and it could include things like mask usage. I refer to that specifically because if you are an employer that is not under the federal mandate, very few employers around the state are implementing COVID-19 vaccine mandates. And the reason why is because they understand that a certain percentage of their employees are vaccine defiant, for lack of a better word. They don't want to get the vaccine, and they are concerned about losing what could be a significant percentage of their workforce. So I hope this committee understands that companies in general around the state are not implementing COVID-19 vaccine requirements unless they are under a federal mandate to do so. That's not universal, but the percentage is very, very small. Many companies, especially those in the hospitality and travel and tourism area, are implementing mask mandates for their employees. And we see it all the time. Whenever we go to a restaurant or if we go to a hotel, employees are generally, not universally, but generally masked. And that's because of a mandate on the part of the employer. Does that qualify under medical mandate? I'm not sure, but if it does, that would impact a large number of employers around the state. The other thing that seems to be missing in this is the length of employment that the employee would have. Under this bill as written, an individual could accept employment with the understanding that there's a vaccine mandate that they would have to comply with if they didn't qualify for a medical or religious exemption. And then the next day say, you know what, I don't want to comply with that mandate, I'm quitting. And now all of a sudden, because of this legislation or this proposal, the employer's on the hook for 6 months of 2/3 salary. That individual could later in the week accept employment with another company. It's easy to find jobs right now and do the same thing over again and over again and over again. So there's already been a discussion about, well, how do we track if the terminated employee gets other employment? And I don't know that there's any easy answer to that. But please recognize that the way this is written, it's sort of like just opening up a savings account for individuals in continuum to take advantage of this legislation. So one thing the sponsor said that I strongly agree with, state governments and federal governments do regulate businesses, and we all understand that, which is why it's really critical for this committee to weigh regulation and what its potential impact and unforeseen consequences could be on employers. That concludes my testimony. I'd be happy to answer any questions.
Thank you very much. Are there questions for Mr. Jouvet? Was that a hand or? No. I did see Representative Love.
Thank you, Mr. Chair. Thank you for taking my questions. I believe this whole vaccine and mask and all the rest, it's all fear-based. Some people are afraid of getting the virus and they'll get the vaccine. Some people are afraid of the vaccine because they don't want to get blood clots and what have you. Okay, one group's fear is no more legitimate than the others. Okay. The worker shortage that we're facing now, you hear about it every day. Especially nursing. I mean, I should have asked this one. You go to the hospital and there's a long wait in that emergency room, 6, 7, 8 hours. They can't fill all the beds because they don't have the nurses to do it. It's my belief, and would you believe that that this has a lot to do with it? Nurses are quitting and going to find jobs with other nursing agencies. We've got a couple right here in the legislature that have done it. They're going to find jobs with other agencies that don't have a vaccine mandate. This thing's throwing a monkey wrench into the whole thing, and I don't know where
that's an awful lot for a would you believe.
Yeah,
if we could keep it to questions about the testimony that we've heard rather than additional testimony from the committee.
Okay. I guess that'd be it.
Should
I can't wrap that around.
I'd like to respond if I could, and I'll try and keep it brief.
Okay, thank you.
Your observation that this pandemic is being driven by fear on both sides, I think is interesting. I've honestly never thought about it in that way, but I guess using myself as an example, which I am vaccinated, and now that I think about it in that way, yes, it was a fear. I did not want to get COVID. As it turned out, I did anyway, but my symptoms were very mild, I think in large part to the fact that I was vaccinated. I think another way of putting that would be people and employers want to do what they believe, based on science and CDC recommendations, is in the best interest of their employees, customers, and people who come into the place of business. So that's a different way of looking at it. But I think what you suggested is an interesting way to look at it. In terms of specifically of hospitals, because the BIA does have many hospital members, And I think you were correct. I think there is a handful of nurses, not very many, because as the previous, Paula Minahan from the Hospital Association testified, the vast majority of people who work in healthcare, nurses, nurse practitioners, doctors, are vaccinated. I am certain we could find examples of people who chose not to and chose to leave employment because of that, but I think the numbers are very small. That, regardless of where you fall on that issue, that doesn't really impact our overall objections to the bill.
Thank you. Are there other questions for Mr. Jubei? I don't see any, so thank you very
Thank you,
much
Mr.
for your
Chair.
testimony. I have one remaining card, Kate Horgan, who represents the New Hampshire Association of Counties, in opposition to the bill and providing written testimony.
Good morning, Mr. Chairman and members of the committee. My name is Kate Horgan. I serve as the Executive Director of the New Hampshire Association of Counties, which is all of your elected and appointed officials in county government. Today, I'm here primarily on behalf of your county nursing home administrators. Representative Sullivan did point out one of our major concerns was that this will impact county taxpayers. There is no exemption for public employers, and your county nursing homes are subject to the federal mandate. I will also point out that in the county homes, we did a quick survey about how many people have chosen to leave because of the mandates that are coming down. No one has been terminated. That includes the 2 counties that implemented the mandate at the end of November, beginning of December last year. And less than 1% of people have been unable to get vaccinated or get an exemption. That includes a mixture of population from our employees, including dietary, maintenance, and our nursing staff. So we've been able to work with people to find a solution for them, so we don't think this bill is necessary. Also, it was just pointed out that there is a workforce shortage in this state. I just want to remind you, as members of your county delegation, you all probably are very much aware that that nursing shortage was in place well before the pandemic. Has the pandemic made it worse? Probably, but it is not a result of the pandemic. We were already experiencing workforce shortages. I did also want to just comment, because I know there's been some discussion about whether or not CMS would take or pull the federal funding. I would just provide the example of Stratford County in September was fined $1,000 for not reporting the exact same vaccine information to CMS that they had reported the week before. No discussion, no negotiation, here's your bill, pay it. And I think that is all I have to offer because everyone else covered everything, but I'm happy to take any questions that the committee has.
Thank you very much for your testimony. Are there questions for Ms. Horgan? Seeing none, thank you again.
Thank you.
And that was the last pink card I had. If there was anybody I missed or was wishing to testify, seeing none, we'll close the hearing on HB 1143 and turn it back over to the chairman, who's doing a much better job of keeping us on time.
Thank you. Opening the hearing on House Bill 1410 and call the prime sponsor, Representative Foster. William Foster. Welcome.
Thank you, Mr. Chairman.
You're welcome.
I'm here today to introduce House Bill 1410. This bill establishes that any private entity mandating through access or employment requirements the choice in a medical decision for its employees or customers in New Hampshire for access to goods or services or employment shall assume liability for damages that can be shown to have occurred to the individual as a result of compliance with the medical mandate. It does several things. The first thing it does is it clearly recognizes and acknowledges an individual or business's right to conduct business, retain employees, and provide access to goods and services as they see fit within the framework of current law. It then says that a private entity mandating a decision or mandating a requirement for employment or for access to their goods and services, that requirement shall come with the responsibility and accountability for any consequences caused by attempted compliance. As the choice is being made, or is being mandated, and being made by private entities without representation or consent of the people of the state, additional burdens will be laid upon the entities. And what it basically does is it grants standing for the moving party upon showing that the moving party has suffered any amount of loss or damage which may have been caused by their attempted compliance with the entity's mandate. So what this does is basically say, if an individual desires to fulfill a mandate to get access to employment or to get access to goods and services, and they do so and are injured by that they have the ability to say, hey, I've been injured by this, and it will give them standing to then have their day in court and prove with a preponderance of evidence that it was actually caused by them complying to that specific individual's mandate. There's a lot. I just sat in on the last bill, and there's a lot of questions about should we or shouldn't we get involved in setting rules for businesses. In reality, this doesn't even do that. If a business chooses not to have a rule or a mandate, they don't have to worry about it at all. That's their choice. If a business decides to have a rule or a mandate that for employment or for access to their goods and services, all this is doing is saying that if you choose to make that decision for another human being, that you're responsible for any damage that occurs to the person if they're trying to comply with it. Now, there's an argument that I've heard from many that say, well, if the person doesn't want to do it, they can just not do it, not work, or not work at that particular business, or not go and get what they're trying to get from a particular vendor or service provider. But the truth of the matter is that what we tend to call rules or mandates revolve around coercion of one sort or another. And coercion, though it sounds like a bad word, is something that all of us do all the time. We've been doing it since kindergarten. Do the right thing, I'll give you a star. Do the wrong thing, I put you in the corner. Okay? I'm not trying to fight that. That's how our world works. That's how our penal system works. What I'm trying to do is say that if you're making that decision, that you're responsible for damages caused by that decision. And that's what I'm trying to do with this bill. So I would ask for your support in this bill so that we can give people some sort of ability to say, hey, I have been damaged by something that you asked me to do. Now, the idea that, well, they don't have to do that, it's true, but if you take an individual, one of the things I learned in the military was that if you torture a person enough, they'll break. Everybody breaks, okay? And then I hear another thing all the time where people say, well, everybody has their price. So if we make the carrot big enough, if we make the plus big enough, well, I can get people to do that too. So eventually, if I make the carrot big enough, or I make the stick painful enough, the person's going to do what I want them to do. They're going to submit at some point. All this is saying that is, if I'm doing that, I need to be careful not to harm people in doing it. That's all. All I'm asking is that we put some laws in place so that when people are making this determination and setting these rules, that they put more consideration. They are very careful to make sure that what they're asking people, what they're asking their employees or other people to do, is safe for those people to do. So I ask for your support in this bill, and I'm willing to take questions on it.
Representative Turcott, followed by Representative Warden.
Thank you, Mr. Chairman. Thank you, Representative Foster. Could you give me an example, just reading starting on 22, where it says a private business entity that imposes a medical mandate, I'm just going to leave employee out for now, on a customer. Could you give me an example of how or where that would apply? In other words, business A puts out a mandate for their customer, and somehow a customer is damaged. Can you give me an example of that?
Sure. What this is trying to cover is that it's very hard to determine when a person's going to submit, when they're going to break. What is it? What good thing or what bad thing is it that's going to cause them, well, I need to keep my job, or I really want to be able to go to these concerts, okay? So if someone says, hey, you can't have access to this, or you can't have a job here unless you do this, okay? What this is going to do is say that if that person decides, well, I'm going to go ahead and do what they asked me, okay, then they end up getting hurt because of it, that they can at that point say, hey, I've been harmed, and I need to be able to be compensated for that harm.
Follow-up?
Follow-up, thank you. Yes, but could you draw me a specific example of a private business and a customer relationship where this would apply? Give me an exact, not a broad one, but.
A customer and an employee relationship.
Not employee,
Okay,
no.
customer.
A business and a customer.
Okay. So you have a business, and it says we require vaccines. You got to show us your vaccine passport to gain entrance into our business for goods and services. So someone goes to that business and they say, hey, I want to come in here, and they say, well, you can't because you're not fulfilling this requirement. And they say, okay, well, I really want to shop here, so I'm going to fulfill that requirement. And they go and fulfill the requirement, and in doing so, they end up getting hurt. Then they should be able to say, hey, I got hurt. Now, this will give them standing so they get their day in court, but they're still going to have to show that it was that particular business's requirement that they were trying to fulfill, and that the damage is related directly to that requirement. So if it's a vaccine passport, you'd have to show a preponderance of evidence that you were harmed by the vaccine. So all this is doing is really giving them standing to do that.
All set? Representative Warden, followed by Representative.
Thank you, Mr. Chairman. Thank you, Representative. If you interpreted this language broadly, it says that if somebody has any damage that happened from attempted compliance with the medical mandate. And I wonder if you share my concern that if that's interpreted too broadly, for example, somebody might be driving to the Walgreens drugstore to get a vaccination, let's say, if that's required by the employer. And on the way there, he gets in a traffic accident because he was trying to comply with this mandate, but it's any damages, and now the employer is responsible for the car accident medical bills. Can you see how it could be interpreted that way?
Well, I do, but in order to do that, you would have to prove, one, that you were going to that Walmart to fulfill a mandate that a particular employer or a particular company had in order for you to have that access. So you'd have to prove that that was the case. And then you would have to prove that it was related directly to that. I don't see that. I mean, it would take a preponderance of evidence. I don't see that happening, but thank you for the question.
Representative Avaloni, followed by Representative Sullivan.
Thank you, Mr. Chairman. Thank you, Representative, taking the question. Can you define private business entity for me?
A private business entity is any private company.
From one person to 1,000?
Yes.
Thank you. Thank you, Mr. Chairman.
Representative Sullivan, followed by Representative Mandeville.
Thank you, Mr. Chairman. Thank you for taking my question. The way I'm not employed anymore, so employee doesn't apply to me, but I am a customer.
Right.
Let's say that I go out, like Mr. Jouvet, I get the vaccine because I don't want to get COVID.
Okay.
But when I get the vaccine, I suffer some sort of damage. My wife was sick for a full day. That was damage.
Okay.
The way I read this, it would appear that at that point, I've been damaged by the vaccine. I can now go after every company for which I'm a customer that has a vaccine requirement for, access, and I can collect damages from each and every one of them because I'm a customer at all of these various companies. Can you respond?
Oh, sure. Well, one, you could go after one. You couldn't go after every company because what you're saying is that one particular company's mandate is the one that caused you to get that vaccine. So once you've done one, you'd be done. And the other thing is you would have to prove that that particular company's mandate's the one that caused you to attempt to get the vaccine. And then you would have to prove that the damage that you suffered was from the vaccine.
Follow up.
Follow up.
I hear what you're saying, but I don't see it in the bill language. Can you point out where all of these requirements for one and done, for example, is in there? It just talks about a customer, and it doesn't say that a particular company would be the one thing that motivated me to get vaccinated. All it says is if I'm damaged by the vaccine, I can collect from any company for which I'm a customer damages.
Well, thank you for the question. I don't see it that way, but and I do believe that in this it says, it is saying that a private company, okay? I understand your concern, and I would be, willing to amend the language to cover that. But I honestly, I don't see it that way, but I'm willing to make changes if necessary.
Thank you. Representative Mandeville.
Thank you, Mr. Chairman. Thank you for your testimony. At several points in your testimony, you used the word injured or hurt, and yet the proposed bill on line 24, for example, talks about any damages. On line 26, talks about any amount of loss or damage which may have been caused. I take it from reading the bill that this is not limited to any kind of injury-based damage necessarily, but could include any kind of economic damage or consequential damage resulting from an attempted compliance with the medical mandate. Did you intend it to be as broad as that, such that perhaps someone who lost a business opportunity could sue for the loss of business opportunity, or did you intend it to be more limited to the kind of damages that occur as a matter of a medical loss or injury?
Thank you for the question. Its intent was not to be quite that broad in the way that you just put it. and again, it's something that I certainly would be willing to amend. I think that overall, its intent is to make sure that there is some recourse for individuals that are severely injured when a company, private entity, makes a decision for them. And that's basically what is happening.
All right, thank you. Any further questions for the representative? Seeing none, thank you very much.
Thank you.
I'd like to call Peter Mcnamara and then Paula Minahan. Peter Mcnamara from the Department of Labor. We are behind schedule, so I would appreciate it if you would be brief. Or not so much brief, but to the point. Thank you.
Thank you, Mr. Chairman. My name is Peter Mckenna, and I'm an attorney with the New Hampshire Department of Labor. This bill would be amending Chapter 275, so it would fall to the Department of Labor to enforce this. And there are a couple of provisions that are specific to the enforcement here at Labor that I wanted to highlight, because they would be of concern if we were to enforce this. The first is specific to the question of damages. Under this bill, damages would not be defined, and so I want to provide some context because for the department, there are a couple of types of damages that we do have encounters with and that we do enforce as it relates to workers' compensation, because we do deal with workers' compensation. And when a worker is injured, there are two kinds of damages that we do encounter. Obviously, one is medical bills. We deal with any kind of medical bills that they incur and the payments for those, as well as any loss of earnings potential. As well as any loss of earnings potential. But there are a number of other damages that we don't ever deal with or calculate. Pain and suffering, emotional damages, loss of consortium. None of those are ones that we ever deal with or calculate. But under this bill, damages is not defined. And so it seems that those would be encapsulated in this definition and they would fall to us to enforce. But they're not damages that we traditionally ever deal with, that our hearing officers ever calculate. And so it's something that just traditionally doesn't fall to us or that the statutes ever impose on us. The second is that labor traditionally and always deals with employers and employees. Those are the relationships that we deal with. Those are the parties that we deal with. This statute would inject a third party into that, and that is customers. We don't ever deal with customers. That's not something that labor has dealt with historically. And so that would be a third party that we would now be adjudicating claims with. And so seeing that this bill is really granting standing to deal with a certain new class of claims, it might make sense if we're going to be imbuing standing for this kind of claim to put it elsewhere because of the issues of damages and this new party, given that labor doesn't deal with these kinds of damages, nor this party. If it were to be put with labor, certainly we take no position and we would find a way to make it work. But I did want to note that on the damages and on the parties, they would both be unusual in that labor has not dealt with either of those in the past. And has been noted in the past in other bills. Don't need to expand on it either, but there is no definition of medical mandate. It can be interpreted very broadly. A limiting definition can be helpful in enforcement. Apart from that, I don't have anything to add and would be happy to take any questions.
Thank you. Any questions for Mr. McNamara? Representative Love.
Did I hear you, thank you, Mr. Chair, and thanks for taking my question. Did I hear you correctly in saying that the Department of Labor takes no position?
Correct, we take no position on this bill.
Thank you.
Seeing no other questions for you, thank you very much for your testimony.
Thank you.
Paula Minahan, New Hampshire Hospital Association, followed by David Dubé. And Ms. Minahan has a memo for us. One of many she's prepared for us this year.
Yes. Thank you, Mr. Chairman, members of the committee. For the record, Paula Minahan, Senior Vice President, State Government Relations, New Hampshire Hospital Association. We are opposed to House Bill 1410. It does require, as stated, on an employer to assume liability for any damages that employee or customer can prove to have occurred as a result of attempted compliance with medical mandates. As has been stated, there's some we find this bill confusing. We actually don't believe it's necessary, and it raises a lot of questions, and I'll just rattle off a couple that have already been actually raised. Medical mandates, not defined. Unclear what the sponsor means by that term, but we're assuming he's referring to the vaccine requirement. Workers' comp already applies, as stated by the Department of Labor. Customer as a condition of access to goods, services under New Hampshire law statutes, New Hampshire labor statutes, does not make sense to us, as stated by the Department of Labor. Attempted compliance, I think Representative grabbed my question. We ran this by some of our HR directors, and they had that exact same question. Attempted compliance, if they were driving to a location to get a vaccine and they got into an accident, what does that mean that the employer would be liable? It's unclear, but that's the exact example that an HR director came up with. There's also federal programs in place, such as the Countermeasures Injury Compensation Program, to provide benefits to persons who sustain serious physical injuries or die as a result of COVID vaccine. This is administered by the Federal Health Resources and Services Administration, a division of USDHHS. I have more, but other examples that HR gave me. But for all these reasons, we are opposed to this bill, and we urge you to find this bill inexpedient to legislate. Happy to answer any questions.
Thank you for your testimony. Are there any questions? Representative Seaworth.
Thank you, Mr. Chairman, and thank you for that testimony. I want to go back to one of the things that you said at the beginning of your testimony was that this bill is not necessary, and I'm interested in some details on that, and I'll make up an example. Let's say I want to go into a hospital for surgery, and the hospital tells me before you do, you have to get this prescription in preparation for coming in. And I don't really want to get it, but that's the condition, so I do, and I'm injured. Do I now have standing to say I was injured as a result of something you did? Is that part of why you say the bill isn't necessary?
Well, I don't know that this bill contemplates that necessarily. It is, we're imposing a medical mandate on an employee, not on a patient or a customer. I guess you could consider yourself a customer. I don't consider patients customers per se. So that is called informed consent. When you are agreeing with your medical provider for whatever surgery or whatever service that is needed, you go through an informed consent process, and that is part of medical liability and all that. So I don't see that really contemplated here. We're talking about employees. And again, workers' comp laws, I think, cover those scenarios. I don't know if I've answered your question, but that's my answer.
I don't see additional hands. Thank you very much for your
Thank
testimony.
you.
Mr. Juve.
Thank you, Mr. Chair. I will be brief because I know you're behind schedule. For the record, again, my name is David Juve, Senior Vice President with the Business and Industry Association. We are here in opposition to this bill. There's been a lot discussed in why it's problematic. A couple of things I would like to add to that, and I actually would like to focus on the whole customer aspect of this bill, because I think Representative Sullivan, I believe, raised a pretty interesting point, of which I became aware of this morning. I made reservations at a restaurant for the weekend to take my wife out, and they clearly said...
Making brownie points, huh?
I'm sorry?
Making brownie points for Valentine's
Yep.
Day, are you?
Right on. Happy wife, happy life. The restaurant clearly indicated proof of vaccination will be required for entry. which is not a problem for us because we're both vaccinated. Nonetheless, if this bill went into effect, I could look at that restaurant and any other restaurant or place of business that has that requirement and file a civil lawsuit saying that I was injured. I don't even really have to be injured to file the lawsuit. The company is, you know, it may be completely without merit, but the company still has to defend themselves. So I think this is little more than a public policy that would result in a whole new cottage industry of lawsuits against employers who are trying to do the right thing in the face of a pandemic. So I would ask that you, I don't know that this bill is fixable. I would recommend that you kill it. Thank you, Mr. Chair.
You're welcome. Representative Mandeville, recognized for a question.
Thank you, Mr. Chairman. Thank you for testifying. Coming back to Representative Seaworth's excellent question, let's say, and you did mention that your group includes some hospitals. Let's say a hospital had a rule that in order to have surgery, you needed to have certain blood work done, and so you went to a place to get blood work done, and they injured you. Would your reading of this bill create a legal obligation of the hospital for the injuries that you had sustained by virtue of the blood testing facility?
I think your question is a good illustration of one of the problems with this bill is that it is so broad, almost anything could apply. The prime sponsor mentioned if you were involved in a traffic accident on the way to get a vaccine, that would apply. Well, what if you ran a red light and created the accident? Is the business entity somehow now responsible for the damage that created? You know, we could probably come up with 1,000 different examples of whether this bill would or would not apply, but to me, that's one of the problems with it.
Representative Love.
Thank you, Mr. Chair. Thanks for taking my question. Correct me if I'm wrong, but I believe that an employer has no right to your, say, for instance, HIV status, Hep C status, and a host of other things. Why did they have access to your vaccine status?
Well, with respect, you are wrong for employers who are under the federal mandate. They are obligated to collect that information and keep a record of it. Of course, those records are confidential the way any employee information would be held confidential, but employers under the federal vaccine mandates do have a requirement to collect that information.
Follow up.
So vaccine mandates and other things, they contradict each other is what you're saying. You know, the federal vaccine mandate, and I guess it's HIPAA where, you know, you're not entitled to my medical background. You know, it sounds like to me like there's a definite contradiction here. And
if that contradiction exists, it's going to take someone far more clever than I to puzzle it out.
Thank you.
Thank you. Any additional questions for Mr. Gervais? Seeing none, thank you very much.
Thank you, Mr. Chair.
Any additional individuals would like to speak on House Bill 1410? Seeing none, I'm closing the hearing, and I'll open the hearing on House Bill 1529 FN and recognize Representative Love to introduce his bill.
Thank you, Mr. Chair. Thank you, committee members. For those of you that don't know me, I'm Representative David Love. I represent Rockingham 6, which is Derry. And I decided to go forward with this bill as a result of a drag queen story hour, they called it. But you know, after looking into it, you know, I discovered that there was no background check done on this individual, and you know, we did stop it at the Taylor Library in Derry. You know, they decided to go, you know, to not have it. Then they were going to do it in a public park, and there was an outrage over that. And then they did it at a private entity, and this individual was dancing with kids, rubbing butts, just really going way too far, and there was never a background check done on them. I later found out that a few years ago in Nashua, there was a drag queen story hour, and later to find out that, the guy was a convicted sex offender. And, there's a hole in our law, I guess is what I'm trying to say. School bus drivers, school teachers, school administrators, school volunteers, they all have to do it. Anybody working with a child, except for in the library. We all received an email talking about the costs and the time concerned, the cost. I'll hit on that in a little while, but, the time. I had to go up to the state police one time to straighten out a background check on a gun purchase. Okay, and, while I ended up getting it straightened out, but while I was there, people were there getting background checks. 10 minutes at the longest was all it took. Okay, 10 minutes, and I think it was $10 at the time. Not a big deal. And not when we're talking about a lifetime of misery for a child that's been molested. If I can indulge into that, I was molested as a child. At 6 years old, 11, 12 years old, full-blown alcoholic, using drugs. My friends couldn't hang around with me. As I got a little older, relationships, I couldn't hold on to anything. Lost a lot of jobs because of the drinking and drugging. Doing some crazy things. Eventually getting sober, and then at 60 years old, finally taking a look at this thing. It was a long time of suffering. A lifetime of suffering. And, for us not to fill this hole, to me it'd be wrong. I feel very fortunate, to be able to sit here, that this kid that went through all that hell and did all that stuff gets to sit as a member of the New Hampshire State Legislature and try to fix this. And I'd hope you'd vote OTP on this, and let's fill this hole.
Thank you for your testimony. Are there any questions for Representative Love? Representative Turcott.
Thank you, Mr. Chairman. Thank you, Representative, for taking the question. Part 2 and 3 just seems to focus on fingerprints. Is that analogous to a lot of other background checks that say? I'm unfamiliar with this at all. So is that something that's typical?
Well, thanks for the question. After discussing this with the State Police Background Check Division, I found out that the federal background check does include fingerprints, and it's cheaper. It's $4 cheaper. $25 for a state and $21 for a federal. So I went with the cheaper of the two.
Are there any other questions? I'm sorry, Representative Warden, followed by I.C. Sullivan. Yes.
Thank you. Thanks for your testimony. My question is on the definition of a background investigation, because in line 4, you say the library shall require a background investigation and a criminal history records check, which makes me think that you mean the background investigation is different from a criminal record. And so I'm just wondering what you mean by background investigation. Is that, call up their parents or call up their past employers? If you agree with me, that needs further definition.
I guess we could probably wrap that into one or the other. I think they really mean the same.
Representative Sullivan.
Lines 28 and 29 on the first page. Says that the trustees may require the candidate to pay the actual cost. Seeing how this includes volunteers, would you think that might shut down the flow of volunteers to libraries if they have to actually pay for their own criminal background check?
See, I put the word may in there for the reason of how important is it. The library would have to make that decision. as far as, having this volunteer. How important is it as far as protecting kids? It can't get any more important.
I have a question for you, Representative. You go on further as off of what Representative Warden said. But further on in in line 6 of page 1, the trustee shall require a federal records check. I don't know what that is.
The federal records check does the whole country. It does a record check for every state. If we do just a state police background check, it's for New Hampshire. So
And you
somebody
feel
could have
that-
moved from Connecticut and been a child sex offender, and they could slip through the cracks.
You specifically referenced the situation in Derry. What I guess the point I'm trying to make here is, just because they're a drag queen doesn't mean they're a criminal. And you want a criminal background check because of that incident? Or was it this other incident where there was another situation where someone was a convicted sex offender in another situation? I just want to make sure I understand the correlation.
Just because they're a drag queen does not make them a sex offender. But neither is a school bus driver, neither is a school volunteer, neither is a teacher. Okay, if you're going to be working with children, you should be checked out, especially if you're going to be rubbing butts with them.
Probably shouldn't be rubbing butts anyway. All right, any other questions? Seeing none, thank you very much. You're welcome to sit in your seat, but you understand you can't ask questions and such. I'm going to call Kathy Grownaway from the Griffin-Free Public Library in Auburn. Growney, Growney.
Hi, thank you. Kathy Growney from the Griffin-Free Public Library. I'm here because on behalf of my town, my trustees.
We can't hear you.
Oh, get closer? Oh, sure. Sorry about that.
Yeah, you don't have to take it off if you
Okay.
don't want to. It's your
If you
choice.
can't hear me,
Just-
let me know. I'll speak up.
Yeah.
My name is Kathy Growney. I'm the library director at the Griffin-Free Public Library in Auburn, New Hampshire, and I'm here because I oppose the bill. We are a small, conservative community of 5,600 people, and like most of New Hampshire libraries, we are the community center for our town. I am the only full-time staff member who did get a background check as policy. So we're not against that, and we understand and are very supportive of the safety of our community. My concern with HB 1529 is the requirement for library volunteers to obtain and pay for background checks. New Hampshire citizens are civically minded and proud of it. They enjoy volunteering their time to help support and build their communities. One example of this for us is we hold an annual book sale consisting of 20,000 items, which is 25% bigger than the size of our library. It's held over 4 days, which is made possible by dozens of community volunteers. These are people that we know, that are patrons of the library, who support their community. They are not random people coming in to volunteer. The majority of volunteers sign up just a couple of days in advance, which does not give them enough time to get these background checks. In addition, Auburn residents are known to be extremely frugal, and the majority of our volunteers are on fixed incomes. They are proud to volunteer their time, but this bill requires them to pay in order to volunteer, which places an undue burden on them and creates a barrier to their community involvement. And the result is we won't have volunteers. And as a one person full-time, I can't run a community center without my amazing, dedicated community members and volunteers. This bill as written has the unintended consequence of being detrimental to our operation as a community center and will have a negative impact on our community and our volunteers' well-being. Thank you.
Thank you. Do you have any questions, Representative Seaworth? Followed by Cullum.
Thank you, Mr. Chairman, and thank you for your testimony. My question is the boundaries of existing state law, if you're familiar with them. So if I volunteer to be a youth coordinator for your library, are there requirements
So the
from the
require-
state or from the town?
Yes, so based on law, as I understand it, you could not volunteer as a youth coordinator. I have a person on staff, a part-time person that works 10 hours a week. They are our children's librarian, and because a volunteer cannot do something a staff member does, they would never do that. So the majority of our volunteers, whether they're moving books or sorting books, they're not alone with kids. They're known to us. They are library community members.
You can ask your own question, too.
Oh, okay. Thank you, and no more questions. I'll now chair if there are further questions. Representative McCallum.
Thank you for taking my question. Could you please explain the necessary qualifications and required education for the term director?
Sure. I have a Master's of Science degree from Simmons College. Plus, I have 20-plus years experience, direct experience being a library director. So I have a master's level degree in training as well as a lot of library experience.
Follow up.
So your master's, what I'm asking is not what your education is. What is the required education
That's the
to have the term director?
I can only speak for my library. And for my library, it is a master's degree from an American Library Association accredited institution. I'm not familiar with a state law that requires that.
Okay. Follow-up, please.
One more follow-up?
So could you tell me if there is any reason at all which you would think there would be a requirement for background checks for anyone as an employee? I'm not talking about necessarily people who volunteer. I'm talking specifically about an employee of any kind in a library.
I have no issue, and as I said, our town for full-time employees does do background checks. I'm not at issue with doing background checks on employees. I think that is a reasonable precaution to take when someone is employed by the town.
Thank you.
Are there any further questions? Seeing none, thank you for your
Thank you so much. I appreciate it.
Next up, I'd like to call Deborah Hoadley, I believe, representing libraries in New Hampshire in opposition to the bill. You're not on.
Is that better? Okay.
Yes.
Thank you for that instruction. So my name is Deborah Hoadley, and I am the library director of the Moultonborough Public Library. The population we serve is about 5,000. However, in the summer, we triple and sometimes quadruple that amount. There is a significant portion of our population who are retired, and they make up a large portion of our dedicated volunteer corps at the library. There is a strong sense of community pride and philanthropic spirit in Moultonborough. The library is known for its community engagement, and we have a strong support for the library. One of the ways that people do show their support is to volunteer, to help with services, programs, landscaping, and, as our previous speaker, our annual book sale. We rely on these individuals, and putting barriers to volunteer will compromise the library services we provide. As a small library, the process of federal background checks would be cumbersome, and require significant staff time to prepare, process, and review all the applications for the amount of volunteers we have. Also, due to the nature of some of our volunteer opportunities, the background checks would not be completed in time for us to bring them on board, especially those arriving in the summer months and only staying for the season. That is our busiest time, and that's when we need the most volunteers. So I thank you today for listening to my concerns and testimony as to why I oppose House Bill 1529.
Thank you for your testimony. Are there questions? Seeing none, thank you again.
Thank you.
I'll make one comment. One of the reasons we're very eager to make sure the microphone's picking you up well is all of these hearings are on YouTube, and they're actually closed captioning the hearings as well, so it's very important that everybody be clearly understood for the AIs over at the Google Palace. Next up, I will ask Denise Van Zanten, and hopefully I got that right, from the New Hampshire Library Association, speaking in opposition to the bill. On. Yep.
Red light, got it, thank you. My name is Denise Van Zanten. I am the current president of the New Hampshire Library Association, and I'm also the director at the Manchester City Library. I do support background checks. We've been doing background checks at the Manchester City Library, the state checks on all volunteers and our employees since I took over as director. However, as you know, New Hampshire libraries pride themselves on providing a welcoming and safe environment for our community members. And to do so, many of our libraries already do the state background check. And all of this guidance falls under our Library Board of Trustees. Library Board of Trustees make the decision as to what the hiring practices are going to be, and most of them follow what their town or city is doing. The added cost and time to administer a federal background check, which I spoke to my city security manager about, and they take 2 to 3 months. Where it's 1 to 2 weeks of the state background checks right now, and the cost of the city was more for this check. But my real concern as the Library Association president is most of our libraries serve populations under 7,500 people, so they're very small, very different from Manchester. And they rely, as we all do, on our neighbors to support many important services at our libraries in the state. And while the bill allows us to put that cost onto the employee or the volunteer, I do feel, as my colleagues do, that this does impact the goodwill and the community spirit in our communities and the support for the libraries. So I thank you for listening to me today and for your service to our state's constituents.
Thank you very much for that testimony. Are there questions? Representative Turcott.
Thank you, Mr. Chairman. Thank you for the question. I should ask this of the prime sponsor, but I didn't, so maybe you know the answer. What's the approximate cost of a background check?
I was told the federal background check for the city of Manchester is $48.50. And for the volunteers, it's $20. And that's coming from a previous police officer who deals with the Department of Safety regularly. So I don't know. That's what I was told.
Follow up?
Just make sure I heard you correctly. $48.50 would be for a full-time employee, $20 for a volunteer, is what you're saying? Thank you.
Representative McKenna.
Thank you for taking my question. So is it safe to say that you would be in favor of background checks as long as they are paid for by the community?
I am in favor of the state background checks. The federal background checks are very labor intensive and require a lot more work. And I was also told that it does not cover the whole country because some states have privacy laws and do not share that information, again, from my city security manager.
Thank you.
Further questions? I have one. If you can help me understand, you said that City of Manchester's library does have a policy of checks on volunteers. Is that universal? Or is there, so earlier someone mentioned like the one-day volunteer who stands outside. Is it does it cover everyone, or is there a scope to that
So at
policy?
my library, we do background checks, state background checks on all employees and on our volunteers. So we do have to plan in advance for certain things. And I do have a lot more staff. And I have a city security manager who actually takes care of taking the checks and doing all the processing for me. So I'm not your typical New Hampshire library, and our trustees do set the policies.
Thank you. Any further questions? Seeing none, thank you very much.
Thank you
for your
very much.
testimony. Next up, I have a card from Catherine Heck, I believe, from New Hampshire Municipal Association in opposition to the bill.
Good morning, committee members. My name is Catherine Heck from the New Hampshire Municipal Association, and we are here to oppose this bill as well. I don't want to be redundant in any of the testimony that you've heard directly from our public librarians. However, I did want to bring forward that many of our member libraries conduct background checks for all of their employees, full or part-time, and for some of their regular volunteers. That's a standard practice because they're regular volunteers. We do feel that this bill will hamper local libraries' ability to plan programs for speakers, a one-time speaker perhaps, activities, or some of the events that you heard about in previous testimony, in addition to the cost associated with that, as many volunteers may or may not be open to paying to have to volunteer. I also want to express that 153 of our communities in New Hampshire have a population of under 5,000. So that's a significant number of public libraries that rely heavily on our volunteer personnel in order to move forward their mission and serve their community. So I can take any questions that you might have.
Thank you very much. Any questions? Representative Callum.
Thank you for taking my question. Would you, as a municipal representative, see any circumstances under which you would actually support this and any changes to get there?
I would have to really go back to our members and see what we might be able to do to amend this bill to perhaps accomplish the sponsor's intent and make sure that our local libraries can continue to function. So I would have to defer and have input from our stakeholders, sir.
Follow-up. Follow-up.
So when you say you would have to go to your members, let me divulge my position. I am also a selectman for the town of Unity. We are a member organization. Does that mean you're going to ask every municipality? Would you send a letter to, or a communique, or a phone call, or something to the selectmen of the town of Unity to let us know that you want our input?
I would have to say most likely not. We've taken a position of opposition to this bill based on our policies that we already have in place that all of our members, including Unity, have developed. However, we would work with particularly the libraries to see how we could make this bill palatable to everybody, if that were the case.
Thank you for the question.
Are there any further questions? Seeing none, thank you very much.
Thank you.
I have one remaining card. Marcia McLaughlin, representing NHLTA, in opposition to the bill, and with some handouts for us.
Good morning, and thank you very much. I'm Marcia McLaughlin. I'm here, one, as the chair of my Library Board of Trustees in Greenland at the Weeks Public Library, and speaking today as the president of the New Hampshire Library Trustees Association in opposition of this bill. And I very first have to say I'm hoping that you all will all vote to make this inexpedient to legislate in its current form. I'd begin by asking why. I did hear Representative Love's reference to what caused him to draw up this particular bill, but Beyond that, I don't know what the problem is that you are trying to fix with this particular bill. I'm not going to reiterate the points that have already been made in any time of depth by other people who've spoken in opposition. Most of the libraries in New Hampshire already do the background checks for their employees, not necessarily for the volunteers. That's on an individual basis. The library trustees have that within their discretion, both on the background checks for the volunteers and employees. They've spoken about volunteerism, and I can only ditto that the impact that would be made on volunteerism by this bill, if you require the background check one. I can speak personally about hiring a new library director this past summer. We made, and I will refer to that in my third point, we made a conditional offer of employment to our new director, and it took 8 weeks in order for us to do both the local and the federal background check. I was very impressed when Representative Love referred to a 10-minute. I'd love to know where that was done, that you could get that done. But in that, it goes to, stated in the bill, that the conditional offer of employment, as I said, mine is not the only library that has experienced lengthy delays in being able to bring staff on board, that making an offer of employment does not mean that the person who's been offered the job can automatically begin working. In our case, it was you had to have the background check completed before we could bring you on staff, which is understandable. I think that that's what you all, Mr. Love, is seeking to have happen, is that they don't begin working until you know. And having these delays, as I said in our case, it really put a very deep hardship on our staff. Again, we're a small community, 4,000 people. We have 7 library employees, only 2 full-time and 5 part-time. So we were short 1 full-time, fully vested employee for that, actually from June through the end of September. So I just go back to my original question, which is why? What are we trying to fix that exists? I'd be happy to take any questions.
Thank you very much for your testimony. Are there questions? Seeing none, thank you again.
Thank you very much.
That was the last card I had. Was there anybody else who was planning to testify? I don't see any, so I'll once again turn it back late over to the chair.
It's actually my fault, and then I pass it on to you. I know what I'm doing. I have Aaron show up just looking for me so I can walk out. I'm opening the hearing today on House Bill 1508 and call Representative Brody DeShanes to bring forth this bill.
Thank you, Mr. Chairman, and thank you to the committee for letting me introduce House Bill 1508, prohibiting the discharge of volunteer firefighters or volunteer emergency medical technicians from other employment. House Bill 1508 is a bipartisan bill that protects an employee from that prohibits an employer from discharging or disciplining an employee who is a volunteer firefighter or emergency medical technician whose failure to report for work was due to the employee responding to an emergency. The bill was formulated with the Office of Legislative Services using language from Maine's and Massachusetts laws that protect volunteer firefighters and EMTs who are late to their day jobs because of an emergency call. The bill was requested by a constituent who is a volunteer firefighter. The constituent explained to me that the recruitment of volunteer firefighters has been extremely difficult for many of New Hampshire's communities, especially in rural areas. One concern many potential recruits raise is possible conflicts with their work hours. They have a concern that if they get called, if they're on a call, there's specific times where these folks can be called in, and that if they take those specific times to be called in, that if an emergency lasts longer than anticipated, it makes it so then they go past that amount of allotted call time where they kind of work and balance out their work schedule, that they can end up being late, and that could lead to discipline or being passed on future opportunities at their current place of work, like promotions or raises. So this is it's a huge concern for folks who want to be involved, want to help their communities, want to serve their communities, but feel as if that it would conflict with their professional work and their future economic opportunities. 1508 is also a public safety bill with a shortage of volunteer firefighters, part-time or volunteer EMTs across the state, especially in rural areas, doing anything we can do to help recruit and retain vital public safety. Oh, wow. Hello? Oh. Yeah. I guess I'm cursed. I don't know. Can you hear me? Okay. We'll go with this for now then. Where was I? It's essential for all of us to have these public safety workers. And these folks keep our communities safe. Time out. Hello? Hello? Oh, is this? Did I do something? Hello? Oh, oh, there we go. Look at that. That's why he's the chairman. Yeah. All right, I'm going to repeat my last point in case the people online couldn't hear me. So it's a public safety bill. These folks, it's important that we retain and recruit volunteer firefighters, especially with the shortage that we have in a number of communities across the state. It's essential for our safety, and it's essential to protect people's lives and property. Without them, life would be much, much more difficult. Should also note the New Hampshire Fire Chiefs Association is supportive of this legislation. They recognize how the bill will improve recruitment and public safety in their communities. And will lastly comment on the fiscal note. In a very roundabout way, the fiscal note essentially says the cost of the taxpayers is next to zero. There may be some cost for litigation in the court system, but that seemed to be the only feasible increase explained in the fiscal note. I think the New Hampshire Municipal Association or some other organization might have mentioned, or maybe towns or something, that they would have to work people's schedules around, and that might have some perceived cost because a lot of public employees are also volunteer firefighters. But I think that's a cost that they would probably be able to easily incur. So with that, I will take any questions on the bill.
Thank you for taking my question. As I read this, it appears that the only instance where an employee would be protected would be in showing up late. It doesn't appear, unless I'm reading it incorrectly, that if someone left work in the middle of a shift in order to respond to a emergency, or if they left early before their shift was over, does not appear that they would be protected in that instance. Is that correct?
To my understanding, the way the bill is written, correct. They also need to get a note from a fire chief, so from the fire chief that they serve under, to show that that they actually were being called, that they're coming back from a duty call. The reason why we didn't do it so then it was they were leaving in the middle of their work shift was because there's kind of an expectation where when you choose your shifts that you're on duty, right, that you can be called in, that you would work that around your work schedule, how it currently exists. So we didn't want to be too stringent on employers to make it so then people were scheduling full 8-hour work days and saying, well, I'm on call, and if I have to leave for theoretically 3 hours of that call, or 4 hours of my day shift, that you're just going to have to deal with it and try to find other help. That would seem a little bit too stringent when there's a labor shortage for everyone. So the idea was just to try to make it so that there's some basic protections for folks who have the uncontrollable thing where they're in the last hour of their kind of their duty shift that they're called to, and they end up, you know, having to do a 2-hour call, and they're an hour late for work, that there's no kind of repercussions because they were doing something that's important for keeping the community safe and protecting lives.
Any follow-up? No? Deworth, Mandeville.
Thank you, Mr. Chairman, and thank you for introducing your bill. My question is to clarify, the language says no employer. Do you mean that of any size down to the employer of a single employee?
Which line is that?
5.
Line 5, thank you. Oh, the very first line, thank you. Okay, no employer. Yeah, I mean, I think the way employer is written into the bill, to my understanding, is employer is anyone who's employed. So I think that would be anyone who, you know, they have a W-2 with any business, whether it's the state government, county government, local government, or any other employer. So.
Representative Mandeville, followed by Representative Warden.
Thank you, Mr. Chairman. Thank you, Representative, for the testimony. I was going to ask the question that Representative Sullivan did about the distinction, and your answer was quite clear. I'd refer, though, to the methodology section, which talks about the need to leave work in addition to failure to report work. That's just the methodology. But if you do look then at the bill text itself, in the first line of Section 2, in the definition of responding to an emergency, it means responding to leaving work to respond to. And that still gave me a little bit of confusion about the distinction between not turning up because you were on a call or leaving because one occurred when you were at work. Could you just clarify that? Beg your pardon?
What line are you talking
Oh,
about?
I'm sorry. The first line of Section 2.
Yep, I see that Section 2. Yeah, I think I'm mistaken. There was a couple of additions of this bill that we had written, and I think my memory served me incorrectly. I was operating, and I introduced a different version that I had written over the summer. I think you're correct, though, that this bill would include also responding to emergencies while someone's on the job. That's my apologies.
Representative Warden, followed by Avalani.
Thank you, and thanks for bringing this bill to us. Question on line 22. You said that somebody's a volunteer unless he or she has worked 975 hours in the last 6 months. Is that an arbitrary figure you came up with, or is it consistent with other statute or labor law? And how did you get to that number?
I think, if I'm not mistaken, I can't remember which statute, but it's based on the statute from other states, from one of our neighboring states, either Maine or Massachusetts. The Fire Chiefs Association had no opposition to the way that was written in their understanding, but I would be open to an amendment if it doesn't make sense with our current state laws, with what we have.
Representative Warden, what were you referring to?
Lines 20, 21, and
There it is.
22.
Okay, good. I was looking for the, thank you. Representative Avalani.
Thank you, Mr. Chairman. Thank you, Representative DeShays. I too have a question on 21 and 22. 975 hours over a preceding 6-month period would make them a full-time, would classify them as full-time position and not a volunteer.
Yeah, I mean, I think that's why it says, but shall not include any person who received compensation for over 9, like it's not including those people. So if someone's worked less than that, if I'm not mistaken.
Follow up, Mr. Chairman?
Follow up.
So 974 hours, they would be covered under this section?
The way it's written currently, yes, correct.
And one last question, Mr. Chairman.
Follow up.
Thank you. Line 18 and 19, where the emergency occurs during a period other than normal working hours of the employee, again, comes into the fact that are we looking to have them be able to leave their job, be late to their job, leave their job early? Because it looks like they can do anything they want as a volunteer firefighter with their full-time position somewhere else.
Mm.
I just want to make sure that we're clarifying that for the employers that would be reading this.
Yeah, I mean, I think I would be definitely open to an amendment where there could be some changes to Section 2, because I can see that as a sticking point, especially to remember many private employers right? But let me just read those lines again. You said 18 and 19, Representative Avalani? Yeah, I can definitely see the discrepancy there with the overall intent of the bill. So I'd be open to an amendment where we change that language.
Representative Turcott.
Thank you, Mr. Chair. Thank you for the testimony. The question I have is, I understand where this might be beneficial to recruitment, but could you tell me on, say, an annualized basis in the state of New Hampshire, how many firefighters or medical techs have been discharged or received disciplinary action by an employer?
No, because we don't collect any data on that, to my understanding.
Thank you, Mr. Chair. Are you aware of any situations where this has actually occurred?
I'm not aware of any specific examples. However, I spoke to this specific firefighter who then introduced me to some other folks that he had tried to recruit who raised this concern as to a reason why they didn't decide to volunteer, right? That they had busy work schedules, that they were worried as if they were late to work, that would end up creating disciplinary actions at their workplace. Whether or not those were, legitimate concerns that they had, that's something that I could say would maybe be up for debate. But it was a concern for volunteer firefighters, well, potential recruits who decided that they didn't want to become volunteer firefighters.
Representative Toomey.
Thank you, Mr. Chairman. Can you hear me?
Yes.
Thank you for taking my question. If an employer chose to not pay the employee for the time that they were missing because of a fire or whatever, would that be considered disciplinary action? Say, for example, it was a fire all night and the employee called in sick for the day. Would the employer be disciplining them if they chose not to pay them for that particular shift?
In my interpretation, no. And the way the bills are written, no. It would just be not compensating someone for work that they didn't do because they didn't show up to work. And obviously it was extenuating circumstances, but if they don't, work and put in that labor, then I don't see how an employer has an obligation to pay someone based on, depending on how the contract is structured and everything.
Okay, thank you.
Representative Sullivan.
Thank you again, Mr. Chairman. If in line 15 and 16, if the phrase leaving work to respond to was stricken from that, would the bill without that phrase still succeed at doing what you're trying to do?
To my understanding, yes, I think that was the language that some of us had discussed previously about adding to make it more expanded when we were kind of discussing, myself and the co-sponsors, of what we wanted the scope of this bill to be. I think this edition right now, which, shame on me for bringing forward for introducing something that I didn't entirely understand its full intent, but we wanted it so then it was, if someone was on a call and they were late to work, there wouldn't be a punishment. And we talked about possibly having it so then if they were at work and they were on call and they were brought out of work, we felt as if that might be too stringent onto employers who already have a shortage of labor right now. So we thought it would be a good balance to try to make it so then people who are late to work, that they're not punished and that they can, feasibly work their schedules around their current work schedule as many volunteer firefighters do. I think there's merit to how it's currently written, but I also think that there's more drawbacks how it's currently written. So I would be more than open to an amendment to striking out the language on lines 15 and 16, leaving work to respond to, and also the word or.
Follow up?
Yeah, I think the or, I don't know if it would be necessary. Maybe the or would still be necessary, but I see what you're saying, Representative. I would be open to striking
We'll
that
leave it to
language.
OLS. But I guess the reason for suggesting that is it seems inconsistent, because at first it says at the commencement of a shift, and then it says or leaving work. So we either need to adjust it one way or the other in order to make it work.
Yeah, no, I'd agree with that, and also changing the language, as Representative Avalani greatly mentioned, how we decide, how long someone has been rendered in the capacity and everything. I think that would be a good clarification too. So then, someone who's worked 974 hours isn't, at a certain point, there should be a better line that might be drawn that's better for this state for understanding who can benefit from this legislation who are volunteer firefighters.
Representative Avalani.
Thank you, Mr. Chairman. Thank you, Representative DeShays again. Section 4, 27 to 29. This is protective legislation that is under the purview of the Department of Labor, and you're taking it out and sending it to Superior Court instead of Department of Labor. Any reason for that?
I can't cite any specific one that I have right now. I can try to get back to you with that, though. But if you think it's better under the Department of Labor, I would, I would agree with your judgment. You've served on the Labor Committee for a long time, so I think if you think an amendment should be made, so then it's under the Labor, the Division of Labor, I think that would make sense.
Thank you, Mr. Chairman.
Welcome. Are there any other questions for the representative? Seeing none, thank you very much.
Thank you.
I have no other pink cards. They have not requested to speak. Would Mr. Mcnamara? Mckenna. Mr. Mckenna, would you please approach? That's my, as the judge would say, please approach the bench.
Good morning, Peter Mckenna from the New Hampshire Department of Labor.
I believe there are some questions for you.
Yes.
Representative Avalani.
Thank you, Mr. Chairman. 27, 28, 29 of the bill. It seems to be a sticking point for me, taking a protective legislation under DOL and putting it and sending it over to Superior Court. Would you guys find that troublesome?
So certainly there are times in which there are dual causes of action in our statute. There are times in which claimants can choose to either take things to a forum within the department, thank you, or they can either send things to the department or they can choose to go to Superior Court. I'm not aware if there are any under this particular subheading, but there are times in which people can make a choice as to where they want to go in a forum. I'm looking at the line in which you're describing. And could you give me the line again, Representative? I apologize.
27, 28, and 29. Section 4.
If you don't have numbers on yours.
Oh, I see. I do see the numbers. Yes, sorry, Chairman. Yes, and so interpreting this, there are two things that could be done looking at this. Reading this, they could go to Superior Court to go forward with this action, but seeing that it's under 275, the department could also issue a warning letter to this employer if they chose to go forward with, if they took disciplinary action, and that warning letter would instruct the employer that they would have 30 days to correct that action, and if they chose not to, and if they did not correct that action within 30 days, we could seek a civil penalty of $2,500. That's what the department would be able to do on its own, or this claimant could go forward under Superior Court under this law. But the department on its own would be able to go forward with the penalty provision, which is the catch-all provision under 273.11. But under this, it would provide its own cause of action, which does exist in some places under the law, but it wouldn't implicate the department. I don't read this as the department would be the one litigating this. It's unclear to me if the department would be the one litigating this or if this simply provides a cause of action for the claimant to go forward against their employer.
Correct. That was my follow-up, Mr. Chairman.
Yes.
That was my question as well. Is it going to go strictly to Superior Court? Is the Department of Labor under protective clauses going to be able to adjudicate this before it goes to Superior Court? And the 1 year, isn't there a limited amount of time where an employee can file a grievance with an employer with DOL? I mean,
So it depends on what they would be filing with the department. In this case, I don't In this case, the department couldn't restore someone to their position if they were terminated. The department wouldn't have the ability to do that. All we could do would be to penalize the employer, and we could warn the employer. So we could say, you have 30 days to correct it, or we could penalize you with a $2,500 fine. So through that mechanism, they could correct it by restoring the person to their position within those 30 days. But if they chose not to do that, all we as the department would be able to do would be to issue the fine. We actually don't have a mechanism where we could order them to restore them to the position. So if they chose to come to us and try to get us to do something under this law, all we would be able to do would be to get that fine, give them the warning first, and then get that fine. If they actually wanted reinstatement, I think they would have to circumvent that process and go straight to Superior Court under this provision. So in that way, it's sort of a strange fit to be under the labor laws in that regard, but it's not, I don't believe that it's completely, I believe there are other provisions under the labor statute in which provide sort of dual causes of action that a person can pursue. I think that there are provisions of the wage claim statute that also allow people to pursue a couple of different tracks that they can go under.
And one last follow-up, Mr. Chairman?
Follow-up?
And that already exists without adding language to this. You can go to Superior Court anyways if you've been aggrieved by a former employer. So that way there wouldn't be a dual edge to this. You're going to get a fine from DOL, and then you're also going to have to get follow-up from the court system, judicial system.
Specific to an emergency responder being fired from...
Correct, or however this is worded.
I don't know specific to this, in a situation like this, I don't know what the cause of action, the existing cause of action would be in terms of if they could go to Superior Court right now and get reinstated. I just don't know what the law on that is existing.
Thank you. Thank you, Mr. Chairman, for your indulgence.
Representative Sullivan?
Thank you, Mr. Chairman. Following up on the same line of thinking, as I would read this, if I was a layperson, I might assume that the only recourse is in Superior Court. Would it be helpful to add some language indicating that, you know, you went into detail about how you start with the Department of Labor and then perhaps to the Superior Court, or you might do both because basically you want the Department of Labor to correct the problem with the employer, but you want the Superior Court to reinstate you to your former position. It seemed, would you agree that we might need some additional language there to clarify the who's in charge of what?
Certainly, I think depending on what you wanted the department to be able to do, there would need to be some more clarity. If you wanted the department to be the sort of the first forum to go to before you went to the Superior Court next, I think there would need to be some additional clarity, and there would need to be some further empowerment of the department to actually be able to order to be reinstated to the position, because right now the department doesn't have that power. We just don't have the authority to order that reinstatement. Right now, if this law were to be passed as such and we were to learn of a situation like this, all we would be able to do would be to send that warning letter that they have 30 days to correct and then to issue the penalty. And obviously that wouldn't be very satisfying, I think, to someone who lost their position, I expect, and then they would want to go to Superior Court if they wanted something more than just us issuing the warning letter and the penalty. So if there was some other track that was envisioned, it could be to make the Department of Labor the first stop and to have a more full hearing on the issue where the claimant could actually bring the claim. That's one option. Have us be the forum where that was heard and empower the department to actually reinstate the position and then have the appeal to that hearing be the Superior Court. Or you could create two tracks. You could say, one, you could have the hearing at the Department of Labor and empower the department, although I think there would be additional language needed to actually reinstate, or they could go to the Superior Court straight from the beginning. I think that would be another way to write it. But our present read of the bill is that we certainly wouldn't have the authority as presently written to reinstate someone to their position if they lost it. And all we currently could do would be that warning and that penalty. But right now, as reading, they could circumvent us entirely and just go straight to Superior Court is how we would read it now.
Representative Sullivan, followed by Representative Cahill.
Are there areas where you do have the power to reinstate? And I'm not talking about this bill, I'm talking about in other parts of the statute. Does the department ever have the ability to reinstate an employee to their former job?
Going through things in my head now, but off the top of my head, I don't believe that we do. I think it is wage, it is restoring wages, but no, I'm not aware of any ability that we have to actually restore someone to their job. It is awarding wages and issuing penalties, but no, I don't believe we have that power. Not aware of it.
Representative Cahill.
Thank you, Mr. Chair, and thank you, Mr. Mckenna. I'm sympathetic to the bill, but I wonder if this is sort of like an accommodation where an employer is obligated, might feel that they're obligated to do it if they can, but if it becomes too much of an issue, then where do they draw the line on how many fires or events, at what frequency is no longer manageable for their business?
And so I think that is, a reading of what the bill, is attempting to strike, the balance that the bill is attempting to strike. And I think if it came to us and I think if we were brought into this, I think that would be the read that we would attempt to make if we were made aware of this and were attempting to decide if it were appropriate to issue that warning letter and attempt to eventually pursue a fine. I think that's how we would attempt to interpret this, and if that was the violation that were committed, that's how we would attempt to read this and see if that was the violation that was committed.
Thank you.
I don't see any more questions, so thank you very much.
Thank you.
Is there anyone else who would like to testify for or against House Bill 1508 FN? Representative Mandeville.
A point of order, Mr. Chairman. Could I request that the primary sponsor come back up just for a moment?
Yes, of course.
Then I would do so.
Representative DeShane, approach the bench.
And as a matter of full disclosure, I should mention that I'm an officer in the Harrisville Volunteer Fire Company. Representative DeShane, thank you for coming back. We've been talking about the possibility of an amendment. I wonder if I could encourage you with the other sponsors of this bill and any input you've received from the New Hampshire Chiefs Association to think about and clarify one way or the other as between a sort of start of shift only or something more broadly than that, because this isn't just about recruitment. This is also about the kind of service that small rural towns get from people who are employed. And it isn't just whether they take a job or not or get a job or not. It's whether they are able to come at all. And so if your group would give some thought to that and provide the committee with input on that question, I, for one, would appreciate it.
Yeah, thank you so much for the question. With every bill that I bring forward in front of committee, I take notes and I write down the exact request that the committee has made. And so I think everyone here has brought up a number of concerns, and I was already planning on drafting an amendment and giving it to your researcher and having them submit it to the committee for you guys' consideration as a place to start. I do that with every bill that I kind of bring forward to a committee, because it should be more on my responsibility to fix the problems that I made than the committee to fix my problems. So that's how I always look at it, and I hope committees appreciate that. But yeah, I have some notes here, and based on the feedback, I'll have OLS draft up something. I'll try to get something to you guys before Friday.
Any other questions for the representative? Seeing none, thank you very much. Does anyone else want to speak in for or against this bill? Seeing none, I'm closing the hearing. We will be back at 1 o'clock. Enjoy your lunch. I'd like to see the Republican members of the committee down in Len's room at the end of the hallway.
don't want to tell you what to do on your own time, but anything that you're doing that enhances your ability to do your job.
All right, ma'am. Ladies and gentlemen, can I have everyone's attention, please? We're going to get started. My mom called. She said she's not waiting anymore. Get going. There's been a lot of moving parts today, guys. We are not going to have an executive session this afternoon. Okay? Which irritates Josh and I greatly because we wanted to get a few things done. So we're going to hear our bills, and then I have a bunch of announcements about some other meeting dates. I was hoping to be ahead of ourselves, but now with a session, House session next week, vacation weeks and everything else, we're going to find ourselves in a crunch. So we'll talk about that briefly, but I just wanted everyone to know if they're waiting for an executive session this afternoon, it's not going to happen. I'd like to open this session on House Bill 1514 FN. Call Representative Cahill to introduce his bill.
Thank you, Mr. Chairman, members of the committee. I am Representative Michael Cahill from Rockingham 17, representing the towns of Newfields and Newmarket. And I'm here today with a bill which I believe addresses a problem that's been ongoing. And yes, with HB 1514 FN, I hope to resolve an issue that leads to disputes over what happens with unused time when employment ends. I have a little bit of history here, several years of claims filed with the State Department of Labor. 24% of them in 2018 were related to this issue. In 2019, it was 26% of the claims. 2021, 29%. We shut up a bit in 20, where there were 42% of the claims involving this issue. And it's mostly because people believe that what's earned, what's on their pay stub, belongs to them. And this is something that I understand in the policy and the practice of the employer sets the tone, it determines that, but there are exceptions, I think, to where we all might agree that the employee has earned and should retain the time, should be paid for it. And I bring you some of them here. I've cited the case where several employees lost their earned time when the business was sold. This was a assisted living center. People weren't making a lot of money, but the employer's policy said accrued vacation is not paid at termination, and they made no provision for their hours to be transferred to the new company where they continued to work in the same positions that they had done before. The prior owner might have paid them or might have transferred the liability. That didn't happen. This was beyond the control of these employees who each lost a few $100s. In another case, an employee lost 3 weeks when laid off, obviously without notice. You don't give people notice. I'm going to lay you off 2 months from now. The employer's policy required that 2 weeks advance notice was needed when requesting time off, and that was, of course, impossible under these circumstances. You earn the time. It's on your pay stub. A layoff happens. Nobody knows when it's going to happen. It happens to you, and now instead of having a job, you're collecting unemployment. So those are the two examples. The other situation is where, and I had to credit our former member Representative Nunez, who gave me this suggestion. The employee leaves in good standing. That is, they've given notice and they work their notice and maybe provide some assistance with training their new hire. They leave amicably. That's to be encouraged. So when that happens, I think it's reasonable that you would say to the person, well, I guess you could have taken the 2 weeks and just left me in the lurch with very little notice, but instead you did the right thing by the company and for yourself, and I wouldn't want you to forfeit that which you've earned because you've really done the right thing. So that's my testimony. And I also have a letter here. I believe you've all received this. This is from the Wendy Hunt of the Greater Nashua Chamber of Commerce, which has, I believe she said, 400 members. At first glance, they saw the bill as it was described, saying that vacation pay must be paid, but upon learning of the nuances, what was covered and what wasn't covered, how it doesn't apply to businesses with less than 15 employees, how use it or lose it is not touched here. Ms. Hunt has written a letter saying that they now endorse the bill, now support it. And that's the sort of thing I think many employers in this state would do, knowing that it doesn't warrant them to pay someone who's wronged the company in some way, embezzled, or done harm to it. Only those who have either the termination not beyond their control, or have, as it was stated here, left in good standing. I think that's a healthy situation to have. I'll be glad to take any questions.
Thank you. Are there any questions to the representative? Representative Mandeville.
Thank you, Mr. Chairman. So in the context of a change of business ownership and having this impact, do you have any ideas about how it has worked or would work differently or better?
Thank you for the question, Representative. In fact, I'm aware of several instances where it has been handled very differently. I once worked for a company that was acquired by another company, which instead acquired two companies at once, and in neither instance was the vacation time or any benefit changed. It carried over under the new ownership. Through this acquisition, I also met my future wife, so there was a good deal all the way around. And, hi dear. And when she stayed with the company and it was sold twice more, and the last time she had to reapply for her job, and in every case, the vacation was not gone, it extended, and that's the right way to do it, I believe.
Any additional questions? Representative Avalani.
Thank you, Mr. Chairman. Thank you, Representative Cahill. On line 6 through 8, could you explain how that works?
6 through 8. Well, again, I think the employer has the policy and communicates it, and it's often explained as to how much time you'll earn and how you can ask request for it and when it will be used and if there's any carryover. I think this is not unlike how the department already requires employers to track payroll, how many hours you've worked. It's related to that. I think this is something that's maybe even buried down in the rules and could come up a bit in the statute like we often like to do. So I think this is how many companies that provide vacations or earned time off or PTO, I believe this is how they operate currently. So it's not really perhaps a new requirement if you already have vacation time, have a process, and if you don't, it seemed like it would be a sensible thing to do, in my opinion.
Follow up. Thank you, Mr. Chairman. In the absence of an accrual system, earned time shall be paid on a prorated basis. Can you explain if the company has less than, say a company has 15 employees as written,
Yeah.
and if they don't have an accrual system, you just walk in, your boss say, hey, I need a few days off, and he decides to pay you. How would earned time shall be paid on a prorated basis if they don't have an accrual system?
Well, I would think if they say to you that we give you 2 weeks a year, then you divide that 2 weeks by the year, or vice versa, and you would determine how much you would get if it was being accrued, depending on when you're leaving.
Thank you.
Representative Warden.
Thank you. Thank you, Representative Cahill. The question is regarding the number of 15 or more employees. Is that number arbitrary, or is that common in New Hampshire labor statute?
Thank you for the question, Mr. Warden. In fact, that information was suggested to me by a woman who operates a business consulting with small businesses, and she said, don't just pick a number, use something that's fairly constant. And when I also talked with Deputy Ogden, and yes, this number 15 is used in other places, although I can't cite which ones they are.
Any other questions for Representative Cahill? Seeing none, thank you very much.
Thank you.
Michael, you're welcome to go back to your seat, but you cannot ask any questions of the presenters. I'd like to call Rudy Ogden, Department of Labor, please.
Good afternoon. Thank you, Chairman. In terms of the department's position, we've spoken on this bill or bills like this in the past. I would echo the words of Representative Cahill to state that we do see this issue come up quite frequently, and what I mean by come up is that we get a lot of calls from folks, usually in or around the time of their separation from employment, where they ask us how this works. And what I mean by that is when folks are considering leaving employment or are being told you're leaving employment, they oftentimes will say, you know, what about the time that my vacation time or earned time? Present law 275-43-5 specifically does clearly indicate that relative to such benefits, if there are such benefits, that they are as prescribed in the employer's policies or the employer's practice. So presently what law says is that if an employer has a use it or lose it policy, or if an employer has other certain conditions relative to making that time become truly earned, that they're able to impose those conditions. So I just point out that that question comes up quite often. As cited by Representative Cahill, a number of the wage claims that we see come up do often involve this as at least an issue. Sometimes there's other issues, but many times when folks leave employment and they file a wage claim, they will cite this as an issue of which they want to have a review or have a decision come through an administrative law hearing. In terms of Representative Avalani's question concerning the proration, I think to the extent we add any additional words to that, I would say that we would read that as saying that yes, if you said you accrue a day a month, they would get a day a month, whereas if you said they get 2 weeks vacation and the person only works 6 months, they would only be entitled to that week. That's how we would see it, and I believe that's how Representative Cahill intended to describe it. Relative to the comment on 15 or more, the other part of the law in which we see that, I'll just give an example, is when it talks about safety summary forms or joint loss management committees. That is something that is triggered when an employer meets 15 or more. So it is something that, I'm not saying 15 is the deciding factor, but that's certainly something that's leveraged elsewhere as a point in which an employer is considered perhaps shifting from very small to something more than that. I'm happy to take any questions or answer any questions that come up.
Is that a question or you're scratching your head, Representative Sullivan? Okay, adjusting your glasses. Representative Seaworth, followed by Avalani.
Thank you, Mr. Chairman, and thank you, Deputy Commissioner, for helping us out here. I know, as you said, we've addressed this bill, similar language, a number of times. I remember, but not the details, that you had discussed with us the issue that New Hampshire does not require that paid vacation be offered. And I think you've shared with us some of the department's experience with that. If you remember, as I remember, maybe you can help me.
Yeah, so to be clear, there is not a requirement in New Hampshire that an employer provide any vacation time. Benefits such as vacation, annual sick, or things of that nature through a New Hampshire employment law, it's the employer's prerogative. The employer can say, I give you two weeks a year, 2 days a year, or nothing. So what we have when we talk about 275-43, it's not a compulsory obligation that they have to provide vacation time. It's saying if they provide vacation time, they can actually then further state such vacation time becomes due according to the following conditions.
Thank you.
Representative Avalani? And then who else today? I'm sorry, I thought you had. Okay. I have, any other questions? I have a question, Rudy. We have some long-held beliefs in this committee and in the state such that an employee's tips are owned by the employee and not the owner, that we've upheld for years. One of the things that I've expressed to Representative Cahill over the years with this bill has to do with not everyone has vacation time or earned time. Sometimes they just have a certain amount of hours. Do with it what you wish. Sick time, house. But one of the things that does bother me is the fact that if someone is working for a company and has for a number of years and has something provided to them that says this is what you're going to have, that company gets bought out and those things go away. What is the department's opinion when there's a change in ownership and the new ownership vacates or changes or alters or takes away those benefits that the original owner has put in place for the employees. What would your standing be on that?
So as Representative Cahill, I think, brought up, those are oftentimes some of the worst scenarios because the way the law reads, the employer who's ceasing operations or doing the transfer, they would hold the obligation, if any. And that's what I mean by that is that if I'm an employer and I say to my folks, you have 2 weeks or 6 weeks of time and you're entitled to that time and you don't lose it, if I sell to a new owner, at time of sale, I should make that right. If I don't make that right, it is not the new owner's responsibility to take care of that. The new owner, unless as part of the purchase agreement they agreed to take on that liability and obligation, they do not hold it. We have had cases in which we have gone after the old employer, and there have actually been cases where we've gone after the old employer and we have had some success. But I would point out that sometimes what happens in these scenarios is when someone is vacating a business and they sell that business and all of its assets and everything else, it then can be very difficult to try and recoup time. So I don't know if that's answering Chairman Infantine, but I would say our view of it is that there is not in the law a equity wand in which to make that right. Truly, the way the law reads is the older exiting employer should make that right. If they do not, it's not the new employer's obligation.
Understood, but the old employer, the laws are in place that they would make them liable for
If their
those?
policy was that the time
If their
remains, if the policy was that what I mean by that is if they essentially would have to have a policy that was not use it or lose it. They would have to have a policy that says when you end employment, you keep your time.
So
Because then when the company ceases operation and employment ended, all of those individuals by rights should have been paid out their time. If that doesn't happen at time of transfer, that's where it becomes a problem because now those folks lost that time. You'd have to go after the old employer. You cannot bring that claim to the new employer.
Understood. So if it was not a use it or lose it mechanism in their employment agreement or whatever form, their employee manual, and the old employer does not provide that, you do have the mechanisms in law right now to go after that, to try to perfect.
There have been instances in which we've done that. I would say we've tried to handle it two ways. One, at times we've tried to see if the new owner will do. We actually will sometimes say, can we see how this was handled? Was there a transfer of that obligation? If there clearly wasn't, then sometimes there's even been discussions, is there any appetite for taking that time over? And then if there's not, then the new employer's out of it, and then we have pursued the old employer. And there have been instances in which we've been able to do wage adjustments and say, okay, old employer, you sold, you now have this liability for those unpaid wages. But I would point out those cases are hard because the old business is actually oftentimes defunct at that point.
Understood, but just to be clear, the law allows, the current law in place allows you to do that.
Yes.
And you don't need any amendments to that law right now because you're doing it and it works in those circumstances.
It could work, yes.
All right, thank you. Representative Love.
I'd like a little more clarification on that. You said should and could. Is it in statute that shall, never mind should and could, you know, the old employer shall pay?
If they owed it, then it is a shall. I'm just
Okay.
pointing out where it should is that it's not always possible to make it actually happen.
Okay, thank you.
No, thank you for the question.
Any further questions for Deputy Commissioner? Seeing none, thank you very much. I'd like to call Dave Juvet, followed by Bruce Berkey. And because Mr. Juvet likes to get fun with me, he says, I'll try not to ramble on.
Oh, you're going to hold me to that, right? Thank you, Mr. Chair, members of the committee. For the record, my name is Dave Juvet. I'm a Senior Vice President for the Business and Industry Association, which serves as New Hampshire Statewide Chamber of Commerce. I'm here today to oppose the bill. However, I would like to recognize the work of Representative Cahill and the many discussions he and I have shared on this issue and say that this year's proposal, I think, is a huge improvement over previous proposals. Having said that, we have some concerns, some of which are practical and some of which are philosophical. I'll start with the philosophical ones. We had discussions earlier today about business regulation and the fact that states and federal governments regulate business all the time, and that's true. And I could say, well, this is just another example of that. But to me, this is a different type of regulation. This is the state trying to regulate what employee benefits should be. And that is something that has traditionally been left to the employer and is based on a lot of things. The employer's ability to afford the benefit, the necessity of the benefit in order to attract and retain employees. And I think we can all agree that all businesses are different and that there is little that currently exists in terms of a standard benefit policy that businesses share. So Representative Cahill and I just have a fundamental disagreement about whether it's appropriate for the state to be designing a one-size-fits-all benefit for employers. We also have, I think, an honest disagreement over whether the type of time that is being discussed here, whether it's called vacation time or paid time off or whatever, is compensation. He believes, and the bill states that it is compensation. We would argue that it is not. It is a benefit, and it's a benefit that is offered to attract and retain employees. And I'll give you an example of why I don't consider it compensation. The employer I work for, the Business Industry Association, has paid vacation benefits that employees accrue based on the number of years that they've worked for the association. It also has, as a part of that vacation benefit, a use it or lose it policy, meaning whatever days I've accrued, if I have not used those at the end of the calendar year, I lose them. I don't get paid for them, I lose them. And in fact, there have been many years where I've not used my full allotment and I received no compensation for that. So I think it's difficult to consider it compensation because to me it clearly is not. There are parts of this bill that I don't have a problem with. Lines 4 through 10, I guess I don't know that it needs to be written into state law, but it certainly is good business practice. And I think it would be in any employer's benefit to do both A, B, and C. So I don't have a strong objection to that. I also don't have a strong objection to certain situations that Representative Cahill and I have discussed. And these situations involved where an employee is laid off because there's a company-wide layoff, and it's a permanent layoff, not a temporary one, as we saw happen frequently during the pandemic. A permanent layoff, and the employee had no idea that this was coming, no ability to use accrued vacation time. And then the second one is the one we've had some conversation on about whether there's a sale from the one company to another. Again, that may be a situation that the employee has no knowledge or ability to act on. I would caution the committee that creating that benefit, you're now getting into merger and acquisition law, which you may or may not want to get into. But I can certainly understand from the employee point of view that they did not have the ability to act on their benefit. I remain opposed to the section of this proposal that says if an employee leaves in good standing, because again, I think it should be up to the employer to decide whether that benefit should be paid out if unused. It shouldn't be a state mandate that employers choose to do, that employers must do so. Thank you, Mr. Chair. I hope I didn't ramble on too long. I'm happy to answer questions.
Thank you. Any questions, Representative Avellati?
Thank you, Mr. Chairman. Thank you, Mr. Juve. So you're okay with the 15 employees?
Thank you for the question. Yeah, that is a commonly used number here in the state. It's used in a lot of different areas, including discrimination laws. And it, were you to move forward with this proposal, which I don't support, but were you to move forward with it, that number of 15 is something that many employers would recognize.
Representative Adagen.
Thank you, Mr. Chairman. Mr. Juve, for context, you referenced philosophical objections to the legislation, and you said something along the lines of it would be the state determining what benefits are. Could you just repeat that line for my clarification?
Yes. The association I represent, which is an employer advocacy group, believes it's inappropriate for the state to try to design work benefit programs, and that should be left to the employer.
Follow up? Thank you. I'm looking at V-A. An employee who leaves in good standing whose termination is a result of a layoff shall be paid for unused earned time no later than the next regular pay period. At no point in that sentence do I see the creation of a new benefit, but merely the state just requiring that benefits that were previously earned to be paid. Where is your disagreement there?
My disagreement is that unless the employer has stipulated as a part of the benefit that earned but unused time will be paid out at the time of termination, you're creating a new benefit.
One more follow-up. So would you then disagree that this is not requiring employees to create a unused earned time or to require them to provide earned time, but that it is your opinion and the position of the BIA that unused earned time being required to be paid to employees who had previously earned it is the establishment of a new benefit?
I believe the latter, if I followed your question correctly.
Okay.
Representative Avalani.
Thank you, Mr. Chairman. Just for clarification, Mr. Duvet, lines 21, 22, and 23 define vacation time, paid time off, and earned time, and shall be considered compensation. Is that where the issue is?
Well, I have a couple of issues. One, considering a compensation, I've already addressed. We believe it's a benefit and it is not compensation. I do have another concern that I didn't mention, which is companies call paid time off a lot of different things. For example, my employer has both vacation time and what we call personal time. And personal time is meant to be used for sick days, which this bill alludes to. But it can also be used if you're a parent and your child is sick and has to stay home from school and you need to stay home to attend to them. It can be used for other reasons if you're having to move on a certain day and it's not a weekend and you can't be at work and move at the same time. It's intended for situations involving employees where they need time away from work that none of us would normally consider a vacation. And this doesn't address how that would be treated.
Follow-up.
Thank you, Mr. Chairman. And then the following line 23 defines sick time or sick day shall not be considered wages. So the state, the purpose of VA would be defining certain times off as compensation and certain words as not compensation. Could you elaborate on that?
I agree that that's what it does, but I guess I would further say again, in my case, my individual case, where I get personal time, paid time off, personal time as a benefit, I can use that if I need to for sick time, or I am eligible to use it for other non-vacation related situations that may come up. And this proposal doesn't really make it clear how that will be treated in terms of should the employee be paid for that unused time or not.
Welcome. Representative Schmidt. followed by Representative Toomey, and then
Thank you, Mr. Chairman, and thank you, Mr. Gervais. Nice to see you again. You used the word benefit as if it were a gift from the employer. In my estimation, it's part of an employee package that is a contract that the employee has with the employer. Certain things are yes, certain things are given, certain things are expected. Also, along with that, are the benefits that are listed. They're not arbitrary. They're listed in the employee contract.
Well, they should be.
And if they're there, then it should be part of this as well, that when you leave, you aren't asking for a gift from your employer. You're asking for them to fulfill the contract that you had agreed with them at the very beginning. Is that true?
I agree with the general thrust of your question. I disagree with suggesting that if an employer offers a paid vacation benefit or a paid time benefit, and it doesn't specifically say that the employee will be paid for earned but unused time when they leave, that they are somehow eligible for that, absent a change in state law. You mentioned a contract. I think in some ways it's semantics, whether we call it a benefit or a gift or a contract. But to the extent that you want to consider it a contract, it should stipulate exactly what the employee is due is a part of their employment. And if it doesn't say that, it doesn't mean that they get it.
Representative Toomey, followed by Manable and Edison.
Yeah, thank you, Mr. Chairman. Thanks for taking my question. Pretty much along the same line as Representative Schmidt. I've worked at a lot of places, and when I'll give the last place I worked, I was given a employee rules and regulations and policies, and I read through that and signed it. Now, that kind of a policy statement can say a lot of things. One of the things could be like you had, use it or lose it. And I had use it or lose it, and I lost some time, probably for the same reasons. I had no problem with that, because that was the agreement. I've also seen policy manuals that say you have, let's say, 10 days vacation, but you have to have worked a full year to be eligible for it, and it says it. And if you leave in 9 months for whatever reason, then you don't get it. No problem there. But if it says in the policy manual, you accumulate 1 day per month of vacation, let's say, that, in my opinion, is no different than an employer's obligation to pay a supplier or a plumber. I mean, it literally is an agreement that the employer makes. Do you agree or disagree with my reading of that?
I respectfully disagree.
Okay, thank you.
Representative Manable?
Thank you, Mr. Chairman. Thank you, Mr. DeVay. Maybe I'm just trying to slice the cheese a little thinner here, and I apologize for that. But following up on the last two questions then, is it fair to say that you would, and none of us are talking about a gift here, we're talking about the concept of a benefit and its relationship to compensation. Would you say that absent a specification by an employer that the employee retains some interest in the value of time off or time off itself, the employee should always understand that the nature of the contract that's been described does not include any right to that benefit in the event that the employee, for reasons beyond his or her control, becomes unemployed?
Let me answer that in a couple of different ways. I did testify that I have a lot of sympathy for employees who, through no fault of their own or no action of their own, either through a involuntary layoff that they had no way of knowing would take place, or the sale of the company that they either didn't know it would take place or didn't understand the impact of it. I have a lot of sympathy for those employees. This bill goes beyond that to get to I think what the thrust of your question was. I think that employees do have a cause for action or the ability to make a complaint with the department if the employer does not live up to what's written in their benefits policy or their employee handbook. But unless that benefit or employee handbook specifically states that an employee will be eligible to be paid for earned but unused vacation time when their employment is terminated, that's not an employee benefit. It has to be stated that it's a benefit. You can't just, I don't believe you can just assume that that is the case. That's not what the benefit says. And I suppose if this were something that employees were aware of or curious about or concerned with, it should come up at the time where they're discussing the benefit package, and then it can be clearly stated.
Representative Adejan.
Thank you, Mr. Chairman. Mr. Gervais, I'm looking at V-A again. For the purposes of this paragraph, the terms earned time, vacation, or vacation time, and paid time off shall be considered compensation and therefore constitute wages due. Would it satisfy the concerns of the BIA to move that language up into definitions closer to new section and provide a more general description of time that an employee is otherwise capable of substituting for paid time?
Respectfully, I think I'd have to look at the language and go back to some of our members that we get guidance from and ask them. So it's hard for me to say yes or no without seeing the actual language you're suggesting. It's still, I'm still uncomfortable with proposals like this that try and spell out what employer benefits should be. And I think some of the questions around the table are illustrating the difficulty in doing that, because there are a lot of variables that go into a benefit package. There are a lot of differences in terms that go into benefit packages, and it's hard, I believe, to try and design a employee benefit that would be applicable for all companies.
Follow up?
Follow up?
Thank you, Mr. Chairman. Well, I'm looking at IA, inform employees in writing of any policy regarding accrual or use.
Representative Adejan, I'm sorry. Where are you referring to? The bill or the law?
The bill.
Thank
I'm
you.
looking at it
Okay,
on the State House website.
Yep, thank
So,
you. I just lost you. All right. Go ahead, I'm sorry.
Thank you, Mr. Chairman. So I'm just going to read the sentence for context. An employer that, no, wrong one. Inform employees of in writing of any policy regarding accrual or use of unused earned time and any limits on accrual or use. Why does that line not provide the kind of flexibility for an employer to be upfront with employees ahead of time as to what benefits they would be able to expect upon separation outside of the mandate?
I'm sorry, but were you referring to the language in the bill here?
Correct.
Line 6 of the bill?
Yep.
I already testified. I don't have a lot of problem with that language. I think that's just standard good business practice. And if businesses aren't doing that, they'll probably at some point or another have an impact associated with that.
No follow-up.
You say no follow-up? No follow-up. Okay. Representative Avaloni.
Thank you, Mr. Chairman. Thank you again, Mr. Gervais. Lines 12, 13, and 14. which would be section 2 under this proposal. One of your companies has a use it or lose it under vacation time, earned time, but they let you bank sick time, say 80 hours over the life of your employment, or up to 80 hours bank period. Under this, if that sick time is sitting there when they're separated, shall not be considered as wages due, they would lose that time, even though they banked it under the policy.
Yeah, I can tell you, my employer doesn't allow banking of sick time. It's a use it or lose it the way vacation time is. But to your question, my reading of this would be that employees would not be eligible to be compensated for that banked time if it is identified as sick time or sick days.
Thank you. Thank you.
Welcome. I see no other individuals wishing to grill Representative Gervais. So thank you very much.
Thank you, Mr. Chair.
And I was just being jovial, guys. I didn't mean to see you were asking good questions. I wasn't trying to belittle any of your questions, so probably shouldn't have said that. Representative, Bruce Berkey, please.
I thought I just got a pay cut for a minute.
Yeah, really.
Thank you, Mr. Chairman and members of the House Labor Committee. For your record, my name is Bruce Berkey. I'm managing partner with Sheen Finney Capital Group, and one of our clients, many of our business clients are concerned about this bill, but specifically the National Federation of Independent Business here in New Hampshire, over 1,400 members in the state of New Hampshire. And as a caveat to one section of the bill, I would say, I don't know specifically off the top of my head, but I would say that the majority of them have fewer than 15 employees. However, that does not have me here supporting the bill. NFIB is opposed to 1514 for two specific reasons and one general reason. And I'll get to the two specifics first. And let me also say that I've had conversations with Representative Cahill as well. They've been very constructive. We have tried to find that common ground. We're not quite there yet, but I will say that this bill is an improvement over previous year's renditions. With respect to the two specific issues that we have concerns about is on line 4, where it talks about the number of employees being at 15. That is a concern because any future legislature could reduce that number from 15 to 12 to 8 to whatever that number might end up being someday. And so it would encompass even more businesses and then with the negative impacts I'm going to share with you. And then the second specific concern is down in beginning on line 17, where it begins to talk about the result of a layoff. And, you know, one's termination can be good and one's termination can be bad in the eye of the beholder, as they say. But certainly because the law is silent, or the proposal is silent, and current law is silent, if I decide to lay off that individual because they have been embezzling from me, I think that I would have a right to, as an employer, to withhold any extra compensation that might have been earned through vacation time or PTO. So that's a concern for the NFIB members. But more generally, NFIB opposes the bill because it really is an invasion of the relationship between the employer and the employee. And it allows the invasive relationship to exist almost for any reason, such as embezzling. What needs to be recognized and adhered to is if the employer has an employee handbook outlining those negotiated benefits, whether it be vacation time or PTO, and the employee can be entitled to that time earned. But without a written policy on unused vacation time or a PTO, the employer needs to have that flexibility in how that time is treated. Laws should not dictate the relationship between the employee and the employer when it comes to this particular area of the relationship. So with that, I would ask the committee to find 1514 inexpedient to legislate, and I'd be happy to try and address any questions you may have.
Any questions for Mr. Berkey? I have one for you.
Yes.
What would your members think, and I know this is tough because, you know, do the best you can in answering it, if you can. What would you think your members would say if you took the first lines 4 through 10 and made those required for employees with over 100 employers with over 100 employees? Just have to outline what the
Well, as
A, B, and C.
Yeah, as Mr. Juve said, it's smart to have an employee handbook. Any employer, every employer should have one. It's good for the employee, it's good for the employer. And so we would encourage something like that. The number 100, certainly better than 15, and would certainly be preferred over the current language.
Thank you. Any other questions?
Representative Adijan.
I'm sorry, Representative Adijan. Sorry, I got John in the way here. Can't say something.
Thank you, Mr. Chairman. Thank you for taking the question. You classified this bill as a, quote, invasion of the relationship between employer and employee. Where would the organization that you represent draw the line as to what is considered an invasion and what isn't? And I can provide an example. Would the organization consider OSHA regulations an invasion between employers in the employee relationship?
Well, thank you, Representative Adijan, for the question. I will say that the NFIB nationally opposed the OSHA regulations when it came to vaccine mandates for, I think it was employers over 100. And so, in general, the NFIB does oppose greater and further regulation where it's not necessary. We've had regulation for many, many years. There's no doubt about that. And some of it has come about as a result of some very bad experiences. And so the business community has learned to live with those. They have built those regulations into the costs of what they produce in terms of when they sell their products. And the preference would be not to have further regulations if it can be addressed in a matter through an employee handbook.
Follow up? Just for clarification, prior to the question, I wasn't referring to the vaccine mandate. I was referring to OSHA regulations more broadly.
Sure.
And I'll throw out another example just to try to establish where this line is regarding the description of an invasion. A requirement that people get paid for the time they work. If an employee determines that an employer would not pay them for that time worked, wouldn't the free market establish that people just shouldn't work for that employer anymore? I'm just trying to ascertain where the line is here, because I think this is something along the lines of getting paid for the work you've done.
Sure. Thank you for your question. I don't think there's a bright red line in any of this. Currently, there's laws on the books with respect to pay, and I'm sure that Deputy Commissioner Ogden would be all over my members or any employer in the state of New Hampshire if they did not pay the wages that have been earned. I think in this instance, this is a contract moving forward between the employer and the employee with respect to the overall package that an employee signs up for when they go to work for a particular employer. And that package is outlined hopefully in a employee handbook, and that the employee has full knowledge of that relationship for while they're there and when they decide to leave.
Thank you.
Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Berkes. As Mr. DeVay has said, and you have said, the expectation is that the terms of employment, the guidelines or the manual for employment will be clear on this, and obviously we all would share that view. Of course, in law, most of the disputes arise from places where something was left unclarified, and the point about what the expectations of the parties then would become a central question. To the extent you can speak for your membership companies, do you think they would consider that a clarity like this in law would both reduce the chance for litigation and or regulatory action and reduce the displeasure and hits to reputation and other adverse effects from a position taken by companies on this issue, which would run contrary to reasonable expectations of the employee?
Thank you, Representative Manaville, for your question. Yes, perhaps a law like this would add clarity, but I think a law like this would also have an impact on compensation for employees down the line. I think that this, by putting employers into a box on this, you lose the flexibility that the employer has in terms of what they want, what they're going to be able to offer to that employee during the hiring process.
Seeing no other questions, thank you very much.
Thank you.
Allison Miliotto? Did I say that right?
Miliotto, yeah. Thank you, Chairman. So my name is Allison Miliotto. I am the owner and partner and HR consultant for Blue Lion. We're an HR consulting company based in New Hampshire. We service small to mid-sized businesses for HR consulting. Thank you for your time and allowing me to speak in opposition of House Bill 1514. Currently, our state is suffering from labor shortages, a mental health crisis, and massive resignation wave. Employers are having to work twice as hard to attract and retain quality employees. Employees are able to call the shots. They're requesting well above market wages and are often receiving them. I believe this proposed legislation is coming at a time when we need to be figuring out how to help employers stay in business and not add more layers of complexity and liability when trying to make business decisions. If you were to be let go from your job today, how long do you think it would take to be gainfully employed again? And I'm talking in almost every industry. I would argue less than a week. In this proposed legislation, it states that if an employee gives notice in good standing, they are to be paid all accrued vacation time. So as a small business owner with 20 employees, I now need to try and fill a position in a labor market that makes that near impossible, while still paying someone that has made the personal decision to leave my business. What safety net are we providing employers for bad employees? While we don't like to make laws for them, we do need to consider them while making legislation that would benefit them. Jane Doe can now hop from job to job, just staying long enough to cash in on her vacation pay. Now you may suggest that it's her next employer due diligence process before hiring. Well, unfortunately, we're only able to ask certain questions to her prior employer, and we've all met Jane. She's a great actress. And that's right, the only person that showed up for the interview for this position. The pickings are slim. I want to offer paid time off to be competitive as an employer. If this legislation passes, do I add a long waiting period to protect myself, in turn diminishing the benefits for most? For simplicity in administration and enhanced benefits to a lot of our clients, enhanced benefits, a lot of our clients have stopped separating sick time from vacation time, and they just lump it together as paid time off. If you're never sick, great, you get a bonus 5 days to spend at the beach. Having staff take scheduled time off is easier for a business to manage. Most businesses encourage their staff to take scheduled time off versus sick time. This legislation encourages employers to split sick time from vacation time to protect their liability. Again, decreasing the benefits for most employees. As a company, we would like to allow our staff to have their time available at the beginning of the annual period. so that they can take it when it is best for them and their family. This is commonly called front-loaded. With the proposed legislation, employers are going to need to be cautious of front-loading time for their staff. This legislation encourages them to have it on an accrual basis. Have you ever worked for a company with an accrual system and had to tell your wife that you couldn't go to Disney on February vacation because you have not yet accrued enough time? Again, this legislation is encouraging employers to provide a diminished benefit for their good employees to ensure they are protecting themselves from the liability they cannot control. When a business puts together their budget for labor for the year, it accounts for someone's annual earnings. The annual amount includes the benefit of time off. If you're here, you're paid to work, and if you have your time off available, then you're paid to stay home. Even with this benefit, the annual amount does not exceed that of an annual amount. With this legislation, employers now need to have a line item in their budget for the liability of all earned time not yet taken. If you quit, I now need to pay you for weeks that you are not going to be working. And God willing, I have actually replaced you and also now paying someone else new to do the same job. Therefore, paying in excess the annual amount I originally budgeted. If we experience a high turnover, that could drastically impact our business and our budget as a small business. Let's look at some industries specifically. How about restaurants? They typically will have more than 15 employees, super competitive industry when it comes to labor, and they want to add great benefits so they can start attracting great employees. Be careful, that one's going to get expensive. It is proposed in this legislation that the unused vacation time would have to be paid by the next regular pay cycle. This is a direct contradiction to RSA 275-44 that indicates upon termination, an employer has 72 hours to pay all due wages in full, yet again, complicating the process for your employers. So in conclusion, I feel that this legislation will push employers to offer diminished benefits and reward employees for changing their place of employment. An employer often cannot control an employee's decision to leave employment. Why should they be rewarded? In closing, I also have an additional question that should be considered. How is this going to affect people that offer unlimited time policies? It is very hard to create legislation that is one size fits all. Should we not let private employers determine their policy based on their business needs, industry, and labor market? Employees have the ability to ask these questions and know in the hiring process how their potential employer handles time off upon termination. In the current landscape and labor pool, to me, it doesn't justify a bill of this measure. And I did just want to add, after hearing all the other questions, the current legislation, in my understanding and interpretation, in the state of New Hampshire, if you do not have a written policy that dictates what happens to your time off upon termination, whether voluntary or involuntary, you are to be paid for it. So if your company chooses not to write a policy, the state does protect the employee and you are required to pay it out. I have case instances of clients that I've supported that have had to pay out weeks vacation because they did not have a written policy. I would agree that when you're going into employment with somebody, that you're making an agreement. You are agreeing to terms of your employment, and this is something that your employer should be dictating. Do I feel that you should write policy requiring them to dictate it? No, but I believe that the statute already protects them should you choose not to dictate how to play in the sandbox, that there is already legislation protecting them if you choose not to dictate how that policy goes. Thank you.
Thank you, Representative Adigin.
Thank you, Mr. Chairman. I want to follow up on the question that you asked at the end about companies with unlimited time off statutes. How many companies do you represent that offer unlimited paid time off?
Off the top of my head, I would not have a number, but I would say it is very industry specific. There are certain industries, a lot of tech companies are going to unlimited time off, a lot of law firms. It's the higher white-collared companies that are typically doing the unlimited time off.
Follow up?
Follow up.
Just to clarify, I'm talking about unlimited paid time off.
Correct, as am I.
Like you never have to come in.
No,
So earn
so
a
the
paycheck.
policy states that you still do have to request time off, but there is not a cap on the amount of time. It's usually in industries, like you've heard from several gentlemen today, that always lose time. It's the industries where people are not taking the time they're provided. So rather than telling you get to take 5 weeks, but you only ever take 3, we tell you take however much time you ever want. Those industries typically are not taking time off. They are dedicated workers that are working 50 to 60 hours a week. They're not taking time off.
Follow up? Thank you, Mr. Chairman. You talked about this creating a burden on employers to have to pay these benefits out. How many minutes would it take for an employer that you represent to sit down and do the cash out option for these benefits were this law to pass?
Can you rephrase the question? You're asking me how much time it takes to cut a check?
Yes.
The time to cut a check would be probably less than 5 minutes.
Thank you.
It's an interesting question.
Representative Seaworth.
Thank you, Mr. Chairman. For some of us who've only worked for larger firms, and that's all we're familiar with, you made some statements that might be a little confusing. You kind of differentiated between the cost of paying a long-time employee while they take a couple of weeks off, and you shuffle the schedule to account for that, and the cost of paying people who don't work for you anymore. And that's a very different, even though it's the same, the pay rate for 2 weeks, you implied those are very different situations on the employer's books. Could you help some of us understand that
absolutely.
better?
Thank you for the question, and I'd love to clarify. So I was describing, you work for me. I've allocated $50,000 a year for your salary. So you're going to work 48 weeks, and I'm going to pay you for 4 weeks to be off, but I'm still paying you $50,000 for the year. You leave halfway through. I now need to pay you out the 4 weeks of time, but I've also replaced you. So I'm now in the rears of 4 weeks that I've had to pay you in excess because I've filled your position. So while I allocated $50,000 for that position for the year, I've now gone over by, let's call it $4,000 in my budget because I'm paying you not to be here, but yet I've now hired Representative Callum to take your place. So I'm paying him to actually work while you're getting paid. And I would like to also add for small businesses to come up with that kind of money on a consistent basis and have that liability on their books that you could choose to leave at any time, and I can't control that, to then carry that weight is a big burden for a lot of small business owners.
Representative Abelani.
Thank you, Mr. Chairman. I'd like to thank you for your testimony. It was very succinct and articulate, and can we get a copy of it?
Yeah, I do have a copy, just one.
Could the chairman get it and give it to the committee?
We'll do so.
Thank you. And a follow-up question?
Yes.
Could you explain a little bit more in detail between a front load and then an accrual basis? It might have confused a few people.
Yeah, thank you for the question. And I do realize after sitting through the earlier testimonies and questions that might be addressed partially in the verbiage where it says that it would be prorated, which I do agree is a very vague statement. So front-loading someone's time off, let's say everyone gets their time on January 1st. Everyone gets a refresh. Companies that front-load on January 1st, you would get your full annual amount in your bank of PTO. So if you're 4 weeks in the year, you get 4 weeks available on January 1st to do what you would like. If you're an accrual basis, they take the 4 weeks and they divide it amongst all your pay periods, so each week when you work, you accrue a little bit of time. So therefore, it takes time for you to build up a bank. Commonly, we do see with clients that offer an accrual system that they do allow carryovers, so everyone's not starting at 0 on January. They do often accompany an accrual policy with a carryover.
Follow-up?
Thank you, Mr. Chairman. Thank you for the follow-up. So a employer who front loads and then an employee takes all their time and then February 1 says, hey, I'm quitting. How does the employer recoup that 4 weeks vacation pay under this law?
Thank you for your question. That's actually a reason that a lot of employers will go to an accrual system. There is no current legislation that protects an employer. There is no amount due. It's not an IOU, and this legislation doesn't address that concern at all. So I don't want to say it's one-sided, but it is a little one-sided in that there is no protection, again, for the employer if you choose to take all of your vacation, which does happen. We commonly suggest that our clients do the accrual base for that reason, so you're not overpaying before the benefit is given.
Welcome, Representative Amenable.
Thank you, Mr. Chairman. Thank you for your testimony. I may have misunderstood it, though, and I just want to be sure I am understanding it correctly. I thought you had said that, say, in the instance of a company with 20 employees and they have a employee manual and it says you'll accrue a 1 week vacation period for each year you work up to a maximum of 5. And so you've worked as an employee for this company for 15 or 20 years or something, and there's a layoff that came out of the blue because of market conditions or whatever it was, and you have not taken any of your, it's almost the end of the year and you haven't taken any vacation. Is it your testimony that under current law or regulation that employer under those circumstances has to compensate the employee for the value of that unused vacation time?
Yes, thank you for your question. So my testimony states that if there is not a policy written, so if you have a policy that states that it is forfeited, then it would be forfeited. But if you do not have, so in the absence of a policy, current legislation states that the employee is entitled to the payout.
Follow up.
Follow up.
Thank you. Yes, thank you. That part I got. I was posing the question with the ambiguity that the policy just said what I said it said, that you're entitled to these 5 weeks. It doesn't say what happens if if you get laid off. It just, there's nothing in the guidelines that say you get credit for it or you lose it. We don't know. In that instance, would you agree with Mr. Berkey and Mr. DeVay that the employee is not entitled to any compensation of any type for that loss?
No, I would not. So currently, my understanding of the legislation is in the absence of the policy that states what happens upon termination. So a layoff, an acquisition, a merger, they're all terminations. The prior employer terminates, the new employer hires. So that termination, if they did not have a policy that stated what happens upon termination, whether voluntary or involuntary, they would be entitled to be paid out.
Thank you.
Seeing no other questions, thank you very much. I like to look at body language, and I see some body language from Rudy Ogden, but I'm going to call him up later, and I think he has a few things to say. So if you mind if I just let our last speaker, and then you can come back up, Rudy? Gary Abbott?
Do you want that?
Yes, please. Mr. Abbott?
Thank you, Chairman, committee members. For the record, my name's Gary Abbott. I'm the Executive Vice President of the Associated General Contractors of New Hampshire. I almost want to listen to Rudy's testimony before mine. We're here in opposition. I think the speakers before me gave a pretty good discussion of the bill, but every time I hear a bill of earned time, I'm going to tell you what flags it for us. It's the word earned. And then in this bill, which people really haven't talked about, is line 12, 13, and 14. I really highlighted what constitutes wages due. This puts in place something very unique in the statute, whether it's for 15 employees or more or whatever. It's constituting a benefit is wages. And I agree with Dave Juvet, who spoke earlier. Most companies started vacation, sick pay for employees to take it while they work. We want people to take time off so they're good employees over the whole course of working for a company. This earned part, and I want to describe my understanding of the law. I'm glad you're going to have Rudy after me, but my understanding of the law, and most of the companies I represent, I would almost guarantee they have company office policies that address these type of things. What you would be compensated when you leave, how your 401k program works. All of these things are in company office policies. I agree there may be some, if a company closes, some of the examples, it might not be in there because companies base their office policies that they're in business. This is how it's going to work, whether you terminate or not. But it's the word earned, and it's been in all of these bills where you earn 10 hours a month or whatever, you know, that the word earned. For me, it's been a benchmark of how a company allocates vacation time, not necessarily it's earned as compensation. And that's the disconnect, is that you could have a company that you get paid your vacation time if you meet other qualifications within your office policies. Like you leave us in good standings, but good standings in the office policy could be you give us 2 weeks' notice. And if you don't give us 2 weeks' notice, you don't get that amount. Companies vary their policies. Not all companies do that. Some companies have other regulations and other decisions based on their own company. There's no one size fits all, and I think that becomes the problem. But I also heard discussions on the first section. The first section to me almost reads like current law. An employer has to do his office policies, gives it to the employee, and if you break those regulations with your employee, Rudy's coming after you. That's what's going to happen. That is, you have it in writing, you're giving it to the employee, you have to meet that. All the companies understand that. So I'm looking at the top part. That's really what a company does with their HR professionals and how the company works. So I understand why people are not having a big problem with that section, because that's what 90% of the companies are doing. But the next part of constitute wages, what the Department of Labor will come in and do is, if they have an employee that says, hey, I don't think I got paid the appropriate wages, they'll come into the company and want to see those office policies. Are you living within your office policies? That's really what they're going to look at, and that's going to be the determining factor. So we've worked with this system for years. This is how it's worked prior to legislation, and companies really know. They've got to spell out how it works. Maybe you have this 10 hours per day, but you're only eligible for 2 weeks if you leave. You know, there's all kinds of different. It doesn't mean you earn it for the 10 years you're going to be compensated for it, because it, as you heard in previous testimony, the liability of the amount. It is a liability. If you're an accountant, you would know at the end of the year for some of these companies, it's a audited liability tax amount if a company policy does pay it out. One of the scary parts of this bill is you may have a lot of companies. Now, I'm confused at the bill. If we write a policy, but I read line 17, VA, it says, who leaves in good standings? Should there be additional language, in good standings according to your company policy? Are we talking that? Or a good standing that you work for me, but the policy doesn't come into effect? I'm a little gray, because policy, what the company has and how that's interpreted, what good standing is. And that's where some of these the company policy says, you got to leave in good standing, but you got to give us a proper notice so we can hire another person, whatever that policy is. I'm not saying everybody's company policy is like that, but different companies are different. Some have use it or lose it. The scariest part is, if you put this in, what happens with all these companies and they just say, there is no wages earned or compensated? And this is where this line 13, if you have a policy in which many companies don't pay out sick leave, but some do. But say you now adopt that as your vacation time, period. We give you 4 weeks a year, but we decide in the policy you don't get paid for any vacation time. I don't think you want to go in that direction. I think companies still want to pay as a benefit, but this sets up some very questionable things. So we like the system that currently is in place. Now, if you were going to draft a bill to address company buyouts, I get it. That's not normally in a company policy. It's not in, there may need to be language that makes it clear what happens at the Labor Department when they do that. I think those kind of situations are unique, but this bill addresses all companies that are 15 or more. So those are our concerns, which put us in place to, at this time, oppose the legislation, because we think the system that currently is in place works. I would thank the committee for listening to me.
Representative Avalani.
Thank you, Mr. Chairman. Just one question. A few of your companies lay off for the season. Would that be considered termination, and would you be on the hook if you brought them back for all their vacation time up to that point? Or do you roll that over into when they come back, because it is a seasonal job?
And I think that varies a lot because we have seasonal layoffs. I know some of the companies are very generous that even during the seasonal layoff, they pay health insurance and they do some other things that, because they're coming back. They may have policies regarding, within their own company, how they handle vacation time and sick time. And it may be choices, but I don't know those situations, but I'm sure they've worked it out, what's best for keep retaining those employees. So this bill, you're absolutely right, it could affect it, because now if they have to pay out where they before were saying, you know, you can come back. But I also think unemployment office, which is over my other shoulder, you know, they have very specific regs that how much money, if they are paying out vacation before you start unemployment. So there's other stipulations. But I don't want to get into the two agency rules. We've got two experts in the room here behind me, and I would leave it to them. But this, if you're trying to address certain specific issues, maybe that would be the way to focus the bill.
Seeing no other hands, thank you.
Thank you.
I'd like to call Deputy Commissioner Ogden. The only reason I call you is I saw you shaking your head. You disagreed with something that was being presented.
Yeah,
And I just wanted you to be able to.
So thank you, Chairman Infantine. And just for the record, Rudy Ogden, Department of Labor. One of the members was asking me. So the one point, and I really very much appreciate the testimony and perspective offered by those before me, just in terms of existing legislation and how we would handle a situation in which there's not defined policy. 275-43-5 says that it's employment practice or policy or both. So I just want to be clear that if we did not have a policy on the books into how such time was handled, by such time I mean earned time, vacation time, or such things as that, we would be looking at what the employer's practice is. So I just want to be clear that presently, as we're administering the law, and I will speak with the testimony afterwards, I'm just wondering where that came from, and I'm hoping it's not coming from us. I'm hoping a question didn't come to us and we answered it that way. But existing law would be that we would look at then the employer's practice. So again, mindful of everyone's time, but I just wanted to clear that up.
You guys can talk about that offline.
Yeah.
Representative Seaworth.
Thank you very much, Mr. Chairman. And since I have you back here, I have kind of a legal question. The term layoff has been used a lot here, and I remember many years ago an HR representative kind of telling us, quit calling this a layoff, it's a reduction in force. And I'm wondering if a term like layoff has legal meaning in terms of, so my understanding, different state, entirely different circumstances, but a layoff was when you suspended the position with the intent on bringing it back. Would New Hampshire look at that term as legally loaded, or can we use it in kind of the
Well, I would say
vernacular?
Thank you for the question, Representative. For our purposes in administering RSA 275 or the other chapters under our title, we would be looking at how it is addressed within that statute or that particular section. If it's not addressed and it's just generally put out there as layoff, we would then be looking at, okay, what's the generally understood term of that? So there's not particular legal meaning in the sense that typically when we looked for particular legal meaning, we're looking for that section, how is it defined within that section or within that chapter or within that title. So again, we would kind of go from there, and in the absence of a specific definition there, we'd be going to just how is that generally understood.
Follow up.
Thank you, Mr. Chairman. If it's not too complicated a question, how is it generally understood?
Again, for us, it would be a layoff is in some ways looked at as I would want to think about it a little bit more, but we see a layoff as different than termination for cause or termination for a specific reason. Layoffs are usually lack of work, lack of financial resources to do it. Again, I'd want to think about it a bit more, but that's where I would start.
Thank you.
Representative Avaloni.
Thank you, Mr. Chairman. Thank you, Deputy Commissioner. Lines 12, 13, and 14 are a sticking point for a few of the presenters and myself. Are we redefining compensation and wages due based upon a benefit?
You are, in the sense that existing law would say they are considered due based upon what policy or practice is. So right now, as speakers before me have said, compensation is being defined relative to this annual or earned time by when the employer says it's earned, therefore it is wages. This would be changing it to say specifically when it is accrued or bestowed in the sense of a front-loading scenario, that it is by that point earned. It is compensation and it's due.
You're welcome. Seeing no questions, thank you very much for coming up again. Is there anyone else who would like to speak on this bill? I have no one else scheduled. All right, being that I'm an hour behind, I'm going to close this hearing. I have to unfortunately leave unexpectedly. Vice Chairman is going to take over the final bill, 1569, and just give me a second to get out of here. Hey. Well, that's funny. That's funny. He said that. That's what he said. What did he just say? He whispered at me, kick him under the table.
I did not do it, for the record.
I apologize.
All right, it seems to have settled down, so I will open up the hearing on HB 1569 and ask the prime sponsor to introduce the bill.
Thank you, Mr. Chairman, and thank you, members of the Labor Committee. At the time of bill drafting, I was seeing things happening in other parts of the country where workers were not laid off, but were barred from entering their workplace so that they constructively were fired but couldn't get unemployment. We never saw that happen here. Our laws already cover this situation in New Hampshire. So the first section of the bill, in my view, is unnecessary. The second section came to my attention as a colonel in the reserves spoke to a lot of issues that he had found with retention because of that. The name of it, the drill pay. But that actually is already in law that's not wages. So I seem to have brought a bill to you that is completely unnecessary. So I would ask that you ITL it.
Thank you. Are there any questions for the representative? Yes, Representative Sullivan.
Probably shouldn't do this, but I did get an email, I believe, yesterday from a colonel in the National Guard who was asking us to address this issue on his behalf. Is he now aware that this is in the statute? And because it sounded like he actually was harmed by this situation. Is he now satisfied and going to get his back pay?
Actually, he is the one who brought it to my attention initially, so thank you for that important question. He actually told me that it was in law. I assume somebody on this committee informed him of that, and so once he was informed that it was covered, he's now pivoting to making sure that everybody within the reserves is aware that those are not wages and that they do qualify for unemployment, even if they are drilling once a month.
Thank you.
Thank you.
Any further questions? Seeing none, thank you very much. I also have a card from Deputy Commissioner Lavers. I think we've been given the suggestion that we simply ITL. If you can quickly shed some light on what's already in the law, I think that might help. And turn on.
Is that better? For the record, Richard Lavers, Deputy Commissioner, New Hampshire Department of Employment Security. So the department doesn't have a position on this bill. The first component of the bill would seek to define or broaden what's considered as totally unemployed, so someone that is unable to access their place of employment. And the second component would exclude from what is considered wages when you're collecting unemployment and what needs to be deducted from your unemployment benefit, the drill pay and inactive duty pay. Just to clarify, that those types of wages, if earned while you're collecting unemployment, still need to be reported to the department. We ask a series of questions on your weekly claim regarding any work or any earnings that you did have. Individuals still need to report that to the department. It's not the individual who decides what gets reported and doesn't. That needs to be reported. The department determines whether or not it's something that is excludable or is going to be applied against your unemployment benefit.
All right, thank you. Are there questions for the Commissioner? I see Representative Avalani.
Thank you, Mr. Chairman. Not to drag this out, but some of the drill stuff, is that considered a stipend or actual wages?
I would have to defer to how it is actually paid to the National Guard. But if it is earnings that are being paid while you're collecting unemployment, it falls within the scope of what needs to be reported. Now, there are many different types of pay, as I understand it, that is received based upon the type of mission on which someone is working, or if it's not considered as a mission. Employment security benefited tremendously from the work of the men and women of the National Guard during the pandemic, and they were a lifesaver to us for everything that they did. But I believe that that type of pay still needs to be reported to us if you are filing for unemployment.
Thank you. Thank you, Mr. Chairman. Thank you.
Any other questions? Thank you very much for coming before us. I don't have any other cards, and seeing no one else who wishes to speak, I'll close the hearing on 1569. That is our final public hearing for today. We had the question. You have a question?
Could I ask Mr. Lavers about 1514?
Can you ask him? Can you ask him offline, since we've technically closed that hearing? So I don't know if everyone here is aware, we had originally planned to have an executive session this afternoon. With the absence, I know the chairman discussed it with some people. We are not going to hold that executive session. As the chairman said, he is trying to arrange the substitute days, and that will have to be worked through the availability of facilities. Right now, he was talking about the 2nd, which is a Wednesday, maybe trying to do some of our executive session then, and then finishing on the 10th of March, which is a Thursday, and I think our final day to do any execs, but that has to be scheduled, so look for the email from him. And if there, looks like everybody's leaving, so if there are no other questions, have a great night.